I am an acting Supreme Court judge. I sit in Supreme Court criminal term. Just an introduction?
That's fine.
Very well. It's
Judge
great
Thompson
to be here
will show you how
tonight.
it's done.
I'm sorry?
Judge Thompson.
It's great to be here.
Brooklyn, good evening. Woo, woo, call me Judge Cheryl. My name is Harriet Thompson, and you fine people elected me to be your surrogate, the second African American to have that position in the state of New York.
After that, I feel insignificant. Giving honor to God.
Amen.
He certainly has directed my footsteps. Certainly to the Borough President, who's on his way, to the President of Church Women United, my President also. I may not come as much as I should, but you know I come.
30 lashes.
My name is Justice Deborah Dowling. I'm elected to the Supreme Court in Kings County. I choose to sit on the criminal side, and that's where I sit.
And Judge Dowling happens to be one of the more senior judges. I think she's been on the bench for over 30 years.
Yes.
And she liked to say that, a senior judge, but I'll take it.
Senior judge.
And she used to be her court attorney before she got elected.
That is correct.
Mm-hmm.
Good evening, everyone. My name is Judge Lorna McAllister, and I sit in civil court, also known as the People's Court, and I used to be Judge Cheryl's court attorney.
Amazing, right?
Good evening, everyone. I'm Theresa Ciccotto, and I'm blessed to be here tonight and to meet all of you. I am an acting Supreme Court justice. I'm sitting in Supreme Court, and I'm one of 5 judges that do matrimonial. Mm-hmm. And that encompasses child custody, visitation, and some other things that we'll get into. It's a pleasure to be here. Thank you.
Good evening, everyone. I'm the Honorable Lisa Ottley. I preside in Supreme Court. I preside over guardianship matters, a motion part and a trial part. I was recently elected to the Supreme Court and the former supervising judge of the civil court.
Good evening, everyone, and I'd like to thank all of you for taking time out of your busy lives and schedules to attend this forum. My name is Carolyn Wade. I am an acting Supreme Court justice in the Supreme Court in the civil term.
I think this is working. All right. Good evening, everybody. My name is Craig Walker. I'm also an acting Supreme Court justice, and based on the newly enacted Raise the Age legislation, I am the presiding judge of the youth part in Kings County criminal term. What's very important about that is when we did the Raise the Age for the criminal justice system, we took 16 and 17-year-olds out of the equation as far as them being charged as adults. That has a lot of ramifications, which I'm sure we'll get into shortly. I'm also representing the men.
Thank you.
Okay,
or the lack thereof. Or the lack thereof.
Or the lack thereof.
You are representing the man.
Thank you.
You're a good representative.
Thank you very much.
Okay, before we start the program, we're going to have Ingrid Martin, who's the Deputy Borough President, bring greetings to us.
Good evening.
Good evening.
Good evening.
Good evening.
Isn't this a glorious evening? Yes. So it's indeed a pleasure for me to be here on behalf of our Brooklyn Borough President, Eric L. Adams, who is en route. However, if he doesn't make it here, because you never know with these things, as an elected official, sometimes you have one plan, but then something comes up. Mm-hmm. I'm here to officially greet you and to welcome you. How many of you have been in Brooklyn Borough Hall before? Okay, so that's a really large number, and I'm glad to welcome you back. And for all of you people who haven't been in Brooklyn Borough Hall before, we really send a special welcome to you. Borough President Eric Adams always believes in letting our population, his constituents, know that this is the people's house. You elected him to serve, and he serves in many capacities and in many different ways. When he was the senator in the 20th district, he and a number of other elected officials used to always host a forum called Meet the Judges. And Judge Robin Sheares was one of the judges that participated in it on a very high level. In fact, she was one of the people who spoke to us about starting that program. So I was with the borough president when he was the senator as his chief of staff, and we used to do it in a very localized way in our communities. And it came back to us again through Robin, Judge Sheares. She said, you know what, why don't we do it again, and let's do it here at Brooklyn Borough Hall. So we're doing it here, and I'm hopeful that if you all like it, that we can take it out into the communities again. I take this opportunity to thank each and every last one of our judges who is with us tonight for taking time from their busy schedules to do this. They're doing this free of charge. They're not being paid. They're elected to serve, and they do that on the bench. But each one of these judges, as you can see, each one of them had to run for their seat. Oh, well, you were appointed, okay. Well, one was appointed, but everyone else had to run for their seat, and that was a very good appointment, smart appointment, okay, had to run for their seat. And they each give back. So it's important for you to know their names, recognize their faces, and when that time comes again, you remember what you need to do, because I can't tell you go vote because we're in a government office, but you have to be mindful of making sure that you take care of people who take care of the community and who give back to the community. So we have a number of women and we have one male, but that's okay, you're representing all of the males, right? And you're gonna do a fine job tonight. So again, I welcome each and every one of you, and I thank you for coming. I want to recognize members from our team. Brianna, Ms. Suggs, come on forward so they can see you. Brianna worked to put this event together, and she was nervous, but I think she did a great job, so we want to recognize Brianna. We thank you for your work. We have our chief of staff, come on down, Ryan Lynch, come on down. Marcus, come, Brianna, come stay. Marcus, come. He's with our compliance unit, so he makes sure that we're all following suit. And we have one of our volunteers with us. Come on down. Come on down, Sister Blossom. So she's one of our volunteers. So in order for us to do what we do in this office, there's a team. Of course, our borough president, who we were smart enough to elect. He's the man in charge, and we all work for him. But he gives us our mission, and we do our best to execute it. So we have a team, and there's other people that help Ms. Brianna put this together, so I don't want to forget our Borough Hall team and our Borough Hall staff. So I also recognize that we have another judge in the house. She's not on the panel this evening, but she's here to support her colleagues, Judge Ingrid Joseph. Do we have any other judges in the audience? Okay, so I'm not going to take up any more of your time. I thank you, Team Adams, Judge Sheares. So I want to thank Judge Sheares and Judge Gonzales for opening up tonight and for hosting and moderating. And I want to thank each and every one of our judges this evening for taking time from your busy schedules.
Honorable Deborah Dowling, who will discuss about Supreme Court criminal matters or criminal term.
Well, let me say this. I've sat in housing court when I started out, so I was appointed. Then I was elected to civil court. Then I sat on the criminal term at 120 Skimmerhorn Street, and I was also at 141, and then I was elected to Supreme Court. Why do I continue to want to sit on the criminal side? Because with the position that I'm elected to, I can sit on either the civil side or the criminal side. And I think it's important to sit on the criminal side because, again, you have a lot of individuals of color who are coming through, and I've heard it said by someone years ago that appearances make the difference, and being able to relate to people can make a difference. I sit in the court where they handle felony matters. So anything that you could be sentenced to 364 days or more would be in my court. We handle homicides, drug cases, robberies, burglaries, you name it, we handle all of that. And I've been doing that, as I said, a long time, well over 14 years, and I was reelected, so I would probably close to 16 years now. It's challenging, but I think it's important for me to do the kind of work that I do. And I try to make a difference. You try to make sure that justice is served, not only for the person who's accused of committing a crime, but a person who a crime has been committed against as well. So it's always walking that balance, trying to do justice for both, because people who are accused of a crime is entitled to have justice. People who have been the victims of a crime are also entitled to justice. So I guess that's my spiel. And well, let me end with this. I always tell people no one's entitled to special treatment. Everyone is entitled to equal treatment.
That's right. Amen.
So y'all got that, right? And Judge Dowling is located at 320 J Street.
The new building,
The
which
new
is not
nice
so new.
building. Next, we are going to hear from the Honorable Cheryl Gonzales, my over here. And she is the supervising judge of the Housing Court, landlord tenant, and she will tell you some things about that.
Okay, we're not located in a nice new building. As a matter of fact, the building that we're in was not originally a court building. It's an office building that has been refitted and not so well to function as a court. We're scheduled to move, and the date keeps moving outwards. It was 2020, it was 2021, it's now 2022, and we are scheduled to move across the street to 210 Geralman Street. Hopefully we will see that day. But in the Housing Court, there are 50 judges in the Housing Court in the city of New York, and 15 of them sit in Brooklyn. And we have, what we deal with are cases involving payments of rent, cases involving possession of apartments, and cases involving repairs. Originally, the court was started in 1972, or said 1973, I'm sorry, I don't remember which year right now, but it was started to accommodate the repairs that were needed. And it has evolved into something much bigger than that now. We only have one part that deals with repairs in Brooklyn and in all the other boroughs. And in the case of Brooklyn, we have 14 other parts that deal with possession and non-payments of rent. But I'll stop right there and we'll talk some more later.
Next up, I'm trying to do this in terms of, they're looking at me like, oh, who's next, who's next? Next is Judge Carolyn Wade. Mental hygiene, right?
Thank you, Judge
Thank
Sheares.
you.
Good evening, everyone. Again, my name is Carolyn Wade, and I have been a judge for 12 years. For the first 5 years, I sat in civil court, and then I was appointed as an acting Supreme Court judge in the Supreme Court in 2012. So the first 5 years was civil court, the last 7 years as an acting in Supreme Court. I have a variety of matters that I preside over, mostly medical malpractice cases, construction accidents, elevator accidents, slip and fall, car accidents, and I've even had a few sexual harassment cases. In addition to that, I also preside in the mental hygiene part, where I ensure that hospitals, specifically psychiatric hospitals in Kings County, comply with the mental health law, Article 9, in terms of how they treat mentally ill people, whether or not they can medicate them over objection, whether or not they can retain them, meaning keep them in the hospital for long, or whether or not they can discharge them. In addition, I also issue warrants after conducting a hearing as to whether or not an alleged mentally ill person should be picked up, brought before the court, assigned an attorney, attend a hearing, and then I will determine whether or not they should be taken to a psychiatric facility. It's a lot of work. I enjoy it, but you have to be committed, you have to be understanding, you have to listen very carefully, and you have to be knowledgeable of the law. And many of you have elected me because I was elected to civil court in 2007, and then I was re-elected in 2015, and I'm certain many of you voted for me, so I thank you. We have a lot of cases and not enough judges, but we're very busy and we all appreciate the responsibilities that we have, and again, God has guided us. I'll say me, but God guides our steps. And the bottom line is that everybody is entitled to equal justice, as Justice Dowling said. They're entitled to be heard, and they're entitled to respect and dignity. If you have any other questions, we can talk about it later.
Okay, next we'll go to Judge Ottley.
Guardianship.
As I indicated earlier, I preside over a guardianship part. That is the bulk of the work that I do in Supreme. I always say to the community when I'm out and about that guardianships are the last resort. And so I try to encourage most of the community, those that will listen, to get your affairs in order, meaning healthcare proxies, powers of attorney, and your last will and testament. It is important to understand that the court wants to exercise the least restrictive means when someone has to come before the court seeking the appointment of a guardian over someone they believe is no longer able to handle their personal affairs and their financial affairs. So again, I encourage each and every one of you, if you haven't gotten your affairs in order, to do so as soon as possible so that you do not have to come to court asking for the court to appoint a guardian over your personal and financial affairs.
We now move to Surrogate Thompson.
Surrogate Thompson, that's who she is. Surrogate
That
Thompson.
was a nice lead-in to tap
Yes,
on yours.
absolutely.
So I'm just going to ask a question. How many in this room know what the surrogate court does? Raise your hand. Look around you and look at the number. That's very few. So I think I'm going to just give you just a little microcosm. This is one of the most important courts in the judiciary, in my opinion. Why? The surrogate determines the distribution and the determination of your property at death. If you think about that, that's everything you worked for all of your life, right? Your personal property, the stuff we own, and real property, the land we own, which in Brooklyn is now worth a lot of money. I can't tell you the fights we see. Get your house in order, as Judge Ottley said. If you own real property, you should have a will. If you don't, we're going to determine how it's distributed. You got that? So this is a really, really important job. In addition, we have the jurisdiction over the public administrator, where we don't know where the heirs are. So they take that over, and they take over when we act crazy fighting and we can't decide which one of the siblings will be getting letters, which gives you the right to do things with that property. A lot of money is involved in this court. The filing fees on some of them are $1,250, $625. So there's some incentive for us to know what that court does, and for us to protect the valuable assets that we own. Deed theft is real. It's not something that just affects you. It affects your family line, your ability to pass on your property at death. And as we say there, you come in through there one way or another. So please keep these things in mind as we discuss these important areas with the other judges. Critical stuff, ladies and gentlemen, at this time in the history of our borough. Thank you.
And I like the way Judge Ottley says, get your affairs in order. I always say, when you're trying to, most times it's an elderly person and they don't want to talk about death, I say to people, don't you want to get the last word about what happens to your stuff, to your items? And then that gets them, because I know most women, we gonna get the last word. So if you have a mother or a father, that's how you try to walk into that conversation.
Okay, next we will go to Judge Ciccotto.
Thank you. You know, ladies and gentlemen, it's important that you get to know us, but it's more important to get to know what our philosophies are in addition to what we do. I do Matrimonial, and if I asked all of you, individually and collectively, what are the two most important things in your lives, I'm going to be presumptuous and assume that you're going to say family and faith. And I'm going to assume that family comes first, or at least is probably the most significant thing in your life. What happens when you build a family? You put your years, your life, your money, your heart, and then it's shattered. When we get married, we don't anticipate that we're going to get divorced. We anticipate that we're starting another family, we're raising children, we're hopefully buying something that we can call our own and have our children inherit. And then what happens is, suddenly people don't get along, they grow apart, perhaps someone cheats, whatever. And then you suddenly find yourself in a situation where the life that you know, the life that you've built, is shattered, and your whole life has now been turned around. And say you're of a certain age. What do? You've been living in a house for many years. Now, because there's a lot of contention and a lot of anger, you may have to leave the house. So now try to get an apartment in Brooklyn. 30 years ago when you were married, the rents weren't $3,000. You weren't getting, most respectfully, hipsters from all over the place whose daddies are buying them brownstones and they could afford to charge incredible rents. So now, where do you go? And then the children that you're accustomed to seeing on a daily basis, now you get to see them every Wednesday night between 6 and 8 for dinner and every other weekend. And if you can't talk to your spouse, then you have to get emails. You want to know what your children are doing. You want to see what they're doing in school, how their health is. So life has changed exponentially. I'm an arbiter of the law, but I also have a moral compass. And what I love about what I do, yes, it's highly emotional. I lose a lot of sleep. I'm sure we all do. But I'll tell you this, if you're not losing sleep, then you're not doing your job right. Because you have a lot of people relying on you. And the reason I love what I do is because I get an opportunity to help mend. I can't cure, I can't necessarily fix, but I can help people move on. Like for instance, you don't realize that someone may be claiming that he wants custody of the children simply because he doesn't want to pay child support. And all of a sudden now you have a custody battle. All right? And then you may not know because when you were married and you might have inherited something from your parents, or maybe you were in an accident and you got a nice settlement. Well, you trust your spouse. That's your partner. That's the person you chose in your life. So naturally, you would put it in a joint account. Well, guess what? Now it's marital property.
Yeah, buddy.
It's not yours. So everything that your parents worked for to give to you is now going to someone that you probably can't stand. So now you have to fight for what's yours, and now you have to tell your children, usually they're small, what's going on. And let me tell you something. Folks get so desperate that they use their children as pawns. And let me tell you something. Children, especially today, they're extremely smart. They're extremely perceptive. And folks don't realize they will remember this. And how you act now, what are you saying to them? That all of this is more important than you. Winning is more important than you. So what I like about this, and my friends up here will tell you, I like to talk and I like people. And this is an opportunity that I not only deal with attorneys, I get to talk to people. And, you know, I get to advise and I get to listen, because you know what, you go into a courtroom, this is your chance to be heard. And you have a right to do that. So that's why I do Matrimonial, and I'll answer whatever questions you have. I'm sorry, I didn't want to hog it up.
We now turn to the person who deals with a very important part of our society, the youth, and that will be Judge Craig Walker.
Thank you very much. Good evening again. So as I introduced myself earlier, and I know we have some new people coming in, I do preside over the youth part here in Brooklyn Supreme. I was elected 7 years ago, and as an elected judge, as the majority of us are up here, there's the real possibility that we don't necessarily go to civil court, even though we're elected civil court judges. Sometimes the needs of the court requires us to go somewhere else temporarily. In my stance, I went to criminal court right here down the street to 120. Usually that's just about a 2-year obligation. At the end of your 2 years, you're able to go ahead and petition to go back to the court that you were elected in. Next year will be 8 years I'll be on the bench, and I've been in criminal court the entire time.
Thank you.
I could not imagine sitting in any other court at this particular time. And the main reason being is because, obviously, the majority of the young people, the majority of the people that come through criminal court, both at 120 Skimmerhorn, also at 320 J Street, are people of color. And at this particular time, and for the past 6 years, I have been the only black male judge in lower criminal, and now that I left, there are none, and I'm the only black male judge in Supreme Court criminal term.
We're clapping, but that's not really nothing to clap about.
It's a reality check, and
We're proud that he is there, but that is not.
And it's not the only reason that I chose to stay there. I'm a fervent believer in alternative to incarceration. I always say it's very easy to lock somebody up. It's very easy just to go ahead and give them a certain sentence. But if you haven't dealt with the underlying issue, the underlying problem that got them there in the first place,
Yeah, buddy.
I tell these defense attorneys, you will have a client for life.
True.
So what I'm glad when I'm able to be here in the youth part, and again, that's anyone 13 to 17 right now in Brooklyn who is charged with a felony crime. And as was pointed out by Judge Dowling, that's anyone who can be incarcerated for 364 days or more. So these are your major assault cases, your gang assaults, your shootings, your murders, attempted murders, rapes, arson. This is what I see. So when I have a 14-year-old who's standing across from me, who's being charged with murder, and I'm looking at that young kid, because they are kids, and people ask, well, what can you do? What do you do? Well, what encourages me, first of all, is the families, to make sure that there's a family member there, and I make sure that I point that out each and every time that young person is before me. I also have conversations with the young people. I talk directly to them. I think it's important. I address them as Mr. or Miss. I don't look at them as the charge. I look at them as the human being they are. Amen. Because what we try to do in the youth part is actually turn these young people's lives around. Yep. When I was sitting in lower criminal and I would do arraignments, and we would look at what's called a rap sheet. This showed all the arrests the person has had from their first to where they are now. 9 times out of 10, the very first arrest usually happened when they were 15, 16, 17-year-old. And now they're 50 or 60 years old. They're on arrest number 40, 50, some of them are in triple digits. So I think, what could we have done maybe for that person when they were that age at 15 or 16 that might have put them on a different trajectory, that could have turned their lives around. And we have a variety of different programs that we work with. We're looking at the person's economic, social, mental health. We put all of that together to create a program for this young person, again, to try to turn their lives around. You know, because at the end of the day, once their case is finished with me, I want to ensure that they're not coming back into the criminal justice system.
Yes.
Some people say, I just want to save one person. I want to save everybody.
Amen.
Before we go on to everybody else on the panel, I just want to recognize another colleague who has come to support us in the name of the Honorable Senria Edwards. Thank you for coming, Judge. Thank you so much.
Okay, now to our panelists from the People's Court, Judge Lorna McAllister.
Thank you, everyone. Good evening. Again, my name is Lorna McAllister, and I sit in civil court. When I was elected in 2015, however, I was asked to sit in lower criminal court, as sometimes when we're elected, we are needed in other courts before we sit in the court that we were elected to. So I did sit in lower civil court, criminal court for 2 years, mainly doing arraignments. But I have now been sitting in civil court for well over a year. And I sat there sometime before, as I said, I was Judge Sheares' court attorney for a few years, where we sat in family court for 2 years there as well. So what we do in civil court, as I call it, the People's Court, the reason that we call it the People's Court is because this is the court where a large number of the cases are, the litigants are self-represented. They are not represented by attorneys. And we preside over a host of different parts. We preside over small claims actions. That's where the claims are $5,000 or less. We preside over the commercial landlord-tenant part, and that's a very important part as well. That I consider also what I would call a quality of life part, because you have people with businesses who sometimes fall into hard times and can't pay the rent, and they're sued and brought to court. And a lot of them are self-represented, and so they come into the commercial landlord-tenant part. The other part that I also consider to be what I call a quality of life part is, I call it the pro se part. We call it special too. This is the part where people come in and they come in for name changes. Number one, a lot of people want to change their name to something else, but more importantly, the host of people coming in there are being sued by either Con Edison or National Grid. They come in, each of them come in twice, 2 days out of the week, where they will come in and try to negotiate with the litigants to see if they can work out an agreement for these bills. This part is a very important part because people are in danger of having their meters seized. And that is a quality of life issue. So when Con Edison or National Grid works out an agreement with the litigant, I make sure, I read the agreement, and I make sure no one will walk out of that courtroom unless I am sure that they understand what they have entered into and that they are able to comply with this agreement. Because you don't want to walk out of there and say, I owe $10,000, I can afford to, I'll pay $1,000 a month for the next 10 months, and you can't. So the one thing that will not happen when I'm sitting there is that you will not walk out of that courtroom unless I'm comfortable that you're comfortable. Because it's very important. We also preside over another part that's mostly a two-attorney part. It's called the no-fault part. That's a part that is
Nobody
very-
likes.
Nobody.
Thank you,
I'll
Judge
say it.
Sheares.
That's attorneys are represented in that part. That's a part where there were car accidents, and now the medical provider is suing the insurance company for payment. They weren't paid money for a certain treatment that was given to a claimant. So that's what we do in civil court, and we also preside over trials. A lot of times the cases will go to trial, and we have to handle the trials as well.
So, yes, but before you, I just want to say this and I'll get back to you. Okay. So remember when Judge McAllister said she makes sure that the people don't leave out of her courtroom? So you heard the introduction. She knows how to do that because she was my court attorney, and I know how to do that because I was Judge Dowling's court attorney. And she made sure that the people understood, and I'm going to tell you this because it happened just today. That one word, sever, everybody gets it mixed up with waive or waiver. And people will walk out thinking that they don't have to pay because they severed the claim. And then when they get sued for that other money, because sever means we're not going to sue you today, but we may sue you tomorrow. But people think it means, oh, I don't have to pay ever. They waived it.
Judge,
Yes.
you remember particularly in housing court, let's talk about that
No,
quickly.
particularly,
Yeah.
but I'm just saying, but the cases come back to us in
at another
special,
time.
in that special two part that Judge McAllister is talking about. So those are the things that judges have to be concerned about when people come. They'll say, yeah, but you have to make sure they understand. And before I introduce the next judge, I just want Judge Ciccotto to say what it is.
I just wanted to talk about no fault. Not only is the boring part that they do in civil court, and when I was there, I cried every day, but we also have, the past several years, we've instituted what we call no fault divorce. And essentially what it is called an irretrievable breakdown of the relationship. And essentially what it does is it facilitates the case to go quicker. There's no defense to it. So if Lorna and I were in a relationship, we were married, and she wanted to go and she wanted to get a divorce, and she wanted, her grounds was irretrievable breakdown, I could not do anything to stop it. So what this did, it also prevented people from being embarrassed, because prior to that, the most widely used was constructive abandonment. And essentially that was that you hadn't had sex for 6 months. And it was difficult for people to allocute and answer questions, no, we haven't had any intimacy or sexual relations. So this is just saying our marriage has irretrievably broken down 6 months before the filing. And you don't have to explain why. And I think this is a wonderful thing, because you know what? There are so many times when people just grow apart or things happen. And it's equivalent, I think, to something like irreconcilable differences that they have in different states. People grow apart, and sometimes you just can't stay together any longer. It's not good for you, it's not good for the partner, it's not good for the children. So I just wanted to say that no fault doesn't necessarily have to be a terrible thing. Thank you.
Okay, that's a good point. Thank you for that,
That is a good point.
Judge Ciccotto. And our next panelist is Judge Dena Douglas.
Hi, good evening again, everyone. I sit, like Judge Dowling and Judge Walker, in Supreme Criminal Term. I've been a judge for 13 years. As many of our career paths have been the same, I too started in lower criminal court. I chose to stay in the criminal term, and I'm in Supreme Criminal, and as I said, this is my 13th year. What I really wanted to speak to, because I know that I'm standing in between you and the opportunity to ask us questions, which is a crucial part of our forum tonight, is to speak about bail reform, because come January 1st of 2020, which is just a little over 2 months away, the bail system is gonna change dramatically throughout the whole city, and it'll have a tremendous impact on you and your family members. And in short, what you need to know is you would be encouraged to come to court for your case, because for nonviolent cases, the judges will no longer be setting bail. And that is a big difference, no matter what the background or history or all the other factors that we had to consider, because our hands were tied somewhat. But now, with the change in the law and the statute that comes in effect on January 1, 2020, don't forget that date, it's changed completely. I don't want to get too deep into the nuts and the bolts and the weeds of it, but what the legislature has done is empowered the community to have the opportunity to have various forms of bail, forms that weren't available to you to try to get a loved one out of jail. If you can show that they can come home, there's a stable environment, there are more resources available to people than there were ever before. So if I can leave you with that nugget, then I feel that I've done my job for the day. I'm a trial judge. I used to be an assistant DA, and I appeared before Judge Dowling, and what I can say is, it was a full circle moment to be able to sit in the same court as a senior respected judge as Judge Dowling. She mentors me from afar, and she mentors me closely. I know it's just invaluable to know that there's somebody who you trust that you can go to whenever you have a question. A judge who's knowledgeable, well-respected, is a trial god in our county. And it's somebody who, as a young judge, I have the opportunity to emulate my career under. I know I've seen how it's done, so I know how to do it. And it's incredible to have that opportunity, so then we are able as judges to provide that service to the community that we serve and those who elected us. So thank you again for giving us the opportunity, and we look forward to your questions.
Thank you. And before we get to your questions, we are going to introduce the hosts, the other hosts, but the host in the man's whose house we are in, our very own Brooklyn Borough President Eric Adams.
Soon to be mayor.
Thank you. I really want to thank our judges. We have some amazing judges here in the Borough of Brooklyn for taking the time after being on the bench all day and doing their administrative judicial duties to come out and just take this extra step. Walking into a courtroom or any type of service that the courts are involved in could be extremely intimidating. And you could have a series of questions to stand in front of that bench and be judged when you have folks, number one, who are really concerned about how we administer justice, but are really concerned. They're really concerned about the city and the communities that we live in. I have interacted with them a number of times, and they are authentic about ensuring the scales of justice are equal, and that the woman that holds those scales cannot have a hole in her blindfold to see who's black, brown, white, or part of any other immigrant group. They do it the right way, and I want to thank them and ask the questions you want to. Don't leave here wondering. This is an opportunity to dig in deep and find out all of these different judges and who and what they represent can give you the answers to the best of their abilities. So again, thank you. I thank Robin Sheares for approaching us and say, let's make it happen, and for actually moving forward. I know my staffer is here somewhere. She's probably moving around, but Brianna Suggs has been amazing in bringing everyone together and making it happen. Again, thank you very much. Thank you, Judge.
And that's how it happens. We just have to ask and be willing to, and it shall be given unto you. So before we get to the question and answers, I guess I'm going to be the last one to give you a little bit about who I am, right? So I'm Robin K. Sheares, and I'm a judge of the civil court. I'm an acting Supreme Court justice, so I do cases in civil court. I take some cases from Supreme, and I do some criminal arraignments on the weekend, right? Y'all forgot to tell them that y'all do. criminal arraignments on the weekend. So I'm just here to make this happen for you all. I think it was myself, Judge Wade, and Judge McAllister. I think we accosted the borough president. You know, I started it, and then I had my backup. And I say, you have all these things in Borough Hall, financial, I see it on TV, I watch News 12, and you never ask the judges to come. So we thank him for allowing us to be here. And now, questions. Oh, and I did sit in family court, but they kicked me out, but go ahead.
They didn't kick her out.
No, I told them.
Let's not be shy. Come on up.
So, question, young lady. Hi.
No, it's not.
He'll put it on for you. My mother told me I take now. That's okay. My mother told me that too. She was right.
No, he's gonna.
Hello?
There we go. Oh, we're ready now.
Hi, good evening. Thank you so much for coming here, everybody. My name is Shoshana. I'm a social worker with a home care agency, a large home care agency, and I visit people after they come out of the hospital or rehab. For example, I do home visits, some of which are in this area, and other areas of Brooklyn is my coverage area. My question is this. I visit patients anywhere from 1 to 3 times because we are short term. So my job is to connect them with community resources and get them to the next step. Sometimes I've had patients who have had legal situations such as the following. One of my patients was working and had a stroke or whatever injury, could no longer pay his rent and was facing eviction notice. Another patient was, I don't know if he was a citizen. His daughter was paying his rent or helping him with the rent, but she could no longer help him for whatever reasons. He was disabled because of an illness or an injury, and the marshal came the day after I visited and locked him out. Another situation is...
What's your question?
Well, I'm wondering what their legal recourses are. Another situation I've run into many times, senior citizen on limited income with a rent-stabilized apartment, has a lot of major repairs that need to be done and tells me the landlord is not making them because they're paying $200 for an apartment in Brooklyn Heights. So I'm wondering, besides calling 311, and some of them have called 311 already, but without any results. So I'm wondering, how can I help these people get the help that they need and stick up for their rights to live in a decent place?
Well, let me say this, and I know I've worked in housing a long time ago, but certainly protective services is available for those at-risk people. And if you're a social worker, then certainly that is one of the resources, because if it is a person who is at risk and by being with a stroke or anything else, then the marshal should be notified so that before an eviction takes place, certain steps are in place to prevent it. And I always tell people, if you know you're having problems with your rent, and if it's a rent-stabilized apartment, you need to have somebody intercede when it's $200 as opposed to $2,000 or $5,000, because then it becomes problematic. Because I know before you could go to public services and get a one-shot deal to assist a person with paying their rent.
Still do it.
But you know, you need to have people who are aware of that and certainly try to nip it in the bud before it becomes $10,000 and the person can't pay.
Yes,
I
have sometimes referred patients to APS, but they will not intervene if the patient has someone else who can help them.
Okay, Judge Gonzales is going to...
And I recognize that that is a particular issue that we deal with Adult Protective Services, not accepting cases if there's someone in the household who can assist the person. But anyone who comes into housing court who is 60 years old or older is eligible to receive free legal help. There's legal aid services for the aging, and there are other legal services providers who can, the tenant can be referred to for assistance. One of the things that you talked about was the conditions in apartments. Even if the landlord does not bring you into court, the one part in the court that deals with repairs, either the city or the tenant can bring a case against the landlord to get the repairs done. All they have to do is come into the second floor at 141 Livingston Street and ask to start an HB case. They will be given an appointment to come to court, and they will be given a date for an inspection to take place of their apartment. So that once you come back to court, we'll know what the conditions are, and then the judge can order the landlord to correct the conditions. If they're not corrected, the tenant has the recourse of coming back to court to have the landlord fined for failing to do the work.
Can I just add one thing? The only thing, if you start the HP action to sue the landlord to make the repairs, then you're not in a position to say, well, my apartment is in disrepair, so I want an abatement of rent. Not everything's going to be a 100% abatement of rent, but certainly those are the kinds of areas, if you're talking about needing repairs and you're looking for a set-off because of the repairs, the apartment is not worth $200, it may be worth $150 or $175. I'm just saying.
I want to just add one other thing. The Department of Social Services, correct, Judge Gonzales, is still in the housing court, correct? Mm-hmm. So remember, when you're down there, there's a resource there. Fourth floor still, Judge, same place?
Yes.
Same place.
406.
Fourth floor, only thing you got to do is go there and show them the dispossess. I am being evicted for not paying rent, and they're eligible for the services. If they're not able to give it there through the housing court, they'll refer you to the center. So no one, unless they don't qualify, should ever be evicted for not paying the rent.
And let me just say this in terms of not only landlord-tenant, but in any court, when you receive papers,
Here we go.
don't hide the papers, because the problem does not go away. It just gets bigger and bigger and worse and worse and worser. Okay? So the thing is, you get a paper, you read it, they tell you to be somewhere, go there. They tell you to answer within 20 days, 30, whatever it is, answer. Because what happens when you hide it, you get evicted. If you hide it, you get defaulted. Then you don't come to court just to discuss your case. Now you have to say to us why you didn't answer, that's the excusable default, and a meritorious defense. Why I think I could win the case. Not one or the other. Both.
Okay, can I
just want
just,
to add one more thing. For the last 3 years, the City of New York has started a program called Universal Access to Justice. And what that is, that the city has funded legal services they're starting by zip codes. And right now, the program is in 11207, 11216, 11225, and 11226. So if you're financially eligible and you live in those zip codes, you can get free representation in housing court.
okay, I just want to add something, but on the side that I said earlier, guardianship should be the last resort, but hearing that you said that this individual had a stroke and the daughter who was assisting with the rent then was unable to assist with the rent, well, this goes back to what you may or may not have in order, i.e. a healthcare proxy, a power of attorney. So what happens, and what I've noticed coming before my part, the guardianship part, is the City of New York, the commissioner, is bringing cases to stay the eviction of those types of individuals who have suffered some sort of illness, whether it's mental illness, that are now coming before the court. And what I hear a lot from the landlord-tenant attorneys when they appear to oppose the stay of the eviction is that, Judge, this is nothing new. This person was all along paying rent, but they shouldn't get a stay because they're unable to pay the rent. Well, this person now is incapacitated. So that's why the city is now involved. So sometimes you have to go the social work aspect, and like the fact that you said that you visit, sometimes you're gonna have clients that are in that type of situation. So you contact APS. These cases are referrals that come to the city and they start to get involved.
Judge, can I just ask one question? So when they come in.
The audience ask a question?
Okay.
Because you could ask her a question some other time.
That was.
So, young man.
Yes, good evening.
Good evening.
This question is directed specifically to the criminal Supreme Court judges in regards to a terminology that I had actually never heard of in my life. I've been just involved most of my life from juvenile well into my adulthood, and I came across a terminology that I'd never heard in any of my court sentences or anything, which was collateral consequences. And I discovered that 15 years after I decided to work with young people, that I was going to live my life a certain way, that I was no longer going back to prison, and I was removed from a job because of my criminal history after working in this particular space 4.5 years. And so my question is more so is that the collateral consequences affect your ability to access employment, housing, occupational licensing. You pretty much have been actually literally sentenced to a life sentence, silent, because it is never mentioned by attorney, prosecutor, or judge. When you ask the question, do you understand by pleading guilty, you're this, do you understand that, and so forth and so on. And so my question is there any measures being made to begin to inform individuals upon pleading guilty that not only are they receiving 60 days, which they think, hey, I'm getting off, I'm getting the 60 days or this year, but they're also informed that this is actually something that will follow you for life. So if you do decide to get yourself together and want to do the right thing, you can still be actually discriminated against or held accountable for the rest of your life for this maybe one moment in your life. And so just want to know, is there any measures from a legal standpoint, from the judge, anyone that have made measures to begin to inform individuals of these things?
Well, if you don't mind.
That's a good question.
It is. It's an excellent question, and I want to answer it just for myself. Obviously, I can't answer on behalf of my colleagues, but as I said, I deal with young people. I deal with the youth. Now, everyone in criminal court is afforded an attorney. It's your constitutional right. So whether that legal aid attorney is explaining the consequences to their client, which is their obligation, I go a step further. I make sure that I talk to each one of these young individuals and I let them know. We have this thing called youthful offender status, and you're probably familiar with that. That is given to individuals who are 18 years and younger, and it's only given out once, but what the youthful offender status does is it ensures that that person does not have a criminal record based upon their guilty plea or a finding of guilt by a judge or jury, but the judge still, by law, has to look at this case and see if this individual should be given youthful offender status. And what that youthful offender status does, as I said, it ensures that that person, based upon those charges, will not have a criminal record. But you can only get it one time. And so when I have these young people who are before me and I explain to them as they're receiving youthful offender status, I said, this is a blank slate for you right now. However, any future convictions that you have can have these collateral consequences. So I ensure that when I'm taking any pleas, and most of my kids, I call them my kids, do receive youthful offender status. They earn it. It's not something that's just freely given. It's based upon what they were able to accomplish while they were there in the part, and so they earn that youthful offender status. But I explain to them, and I make sure that it's crystal clear that they cannot get this again, and that any future convictions can have possible collateral consequences. But there's also the relief from civil liberties, and I will let Judge Dowling.
Well, let me say this for all defendants, and a lot of times people will say, well, Judge Dowling, you're gonna talk them out of taking the plea. And I don't care whether I do, because it's just that important. And if a defendant does not have a criminal record, I tell them the best way that I know how to describe it, because after you enter that guilty plea today, you will have a criminal record. And the best way that I know how to explain it to a lay person is on those forms that they ask you, have you ever been convicted of a crime? After you enter this guilty plea today, your answer to that question has to be yes, because you will have been convicted of a crime. And certainly I'm saying what you're saying, even fair jumping. If you have a crime is a crime, and a crime is a misdemeanor by fair jumping, and you're subject to 364 days in jail, technically, because that's the maximum. And a lot of times people do. The number of defendants that I see have already been convicted of crimes. But the other thing that the state imposes is the mandatory surcharges.
That's a big
one.
one.
A lot of times, what an attorney will say to me as a young man, and I may have people 25 or whatever, oh, enter a judgment against my client. I'm like, no, I'm not gonna enter a judgment against this person, because if he gets a job or if he comes into any money, that judgment will increase by 9% interest rate over the terms, and it will expand exponentially. And I said, this person is going to be stuck. I would rather them try to pay it off $10 at a time, $20 at a time, because I don't have the ability to waive the mandatory surcharges. Before I could, but then the legislator got smart or whatever. When I say smart, what they said is that no judge can waive a mandatory surcharge. And I don't know if you know, mandatory surcharge for committing a felony is $300. Then you have to pay $50 for a DNA fee. Then you also have to pay $25 for a crime victim assistance fee. If in fact it's a sex offense, then you have to pay $50 for a sex offender fee and $1,000 for a supplemental sex offender fee. So that's a total of $1,425 that this person must be responsible for paying. And so it's important, I think, to either have them attempt to pay it off along and along, rather than to be stuck with a judgment where they could be their wages can be garnished. But I don't know if people will say, you know, that by entering into this guilty plea, that it's going to follow you for the rest of your life. For the most part, I think if it's a person who's being a first offense, I would explain it to them. But if it's your third, fourth, and fifth, now come on. There's certain things you should know by then. If it's your third and fourth felony offense, I'm not going to quite honestly say, well, you know it's going to follow you, because the other first 1 and 2 followed you. So the third and fourth is just going to follow suit. But it's important to avoid the first one. But after you're convicted of the first and second one, the collateral damage is done after the first. And that's the ones we need to take time with.
What I also wanted to add is, again, since myself and Judge Walker and Judge Dowling are the three criminal Supreme Court judges on the panel, is that we don't have to take a plea. So we often will come across a case, the attorney will say that my client wants to enter a plea, but the plea is up to the judge whether we're going to accept it or not. We all do very thorough questions, as you've heard my colleagues describe, before we get to the point or while we're going through the plea. But there are, for a number of reasons, we can say that we will not accept the plea in this case. We could think that the plea is not fair. We could think that the defendant before us does not truly understand the consequences of the plea. It could be if there's somebody that's young, that their family member has expressed a great concern over the plea. It could be that the person has a certain mental illness or challenge or disability that they don't understand the plea at that time. So part of what Judge Dowling ended on is there are areas that we have control over, that we exercise and we're thorough with that control, and then there's some areas where we don't, and we have to exercise a balance in what we do.
I want to just add one other thing, because it's been one of my pet peeves about the surcharges and the judgment. I think it's important to remember that once a judgment is entered against you and you don't pay it, that affects your ability to find a place to live. Critical stuff. You understand what I'm saying? So you go down there and you do a $250, they're going to run your name and they're going to come up. And every landlord, that's any landlord worth their salt, is going to run a credit check. And just a little $250 surcharge can turn into $1,000, as I think the judge certainly illustrated, and that stops you from going and living to the place that you want to live. So it's something that if you do the crime, you're going to deal with this, but no, as you've given us in terms of your example, I told people that when I sit in criminal arraignment, because nobody else did. I had another judge, Judge Joseph, who did the same thing, because we knew that that was critical. Most of the time, if you're coming right out of jail, that means that you may or may not have a place, and if you're trying to find a place, that's going to be the thing that's going to stop you from getting something. It's something as small as that. So that's important to remember also, not just the garnishment of the wages, because sometimes the brothers don't have a job.
But let me just ask this to the criminal judges, criminal court judges. But there is an allocution that you have to give as to collateral consequences.
There is. I think that what we're also...
Okay.
I don't think there is.
I would say it's not necessarily, it's not, well, let me say, there is an allocution.
Like allocution.
And there are questions concerning whether that you understand that you're pleading to a crime and the consequences if you get convicted of another crime in the future. So there are certain boilerplate questions that we have to ask. But I think that what the three of us are speaking to is that quite often, especially when somebody comes before us as a youth, or it's their first major case, that we go above and beyond and we ask the extra questions.
Thank you.
What I just wanted to say is that folks don't want to come to court. It's like going to the doctor's office. What I'm hoping that this has done is demystify the system. As Justice Sheares says, if you get a notice, come to court. There are so many programs that will help you. It doesn't necessarily mean that you're going to suffer. You see us. You've heard what everybody tries to do to make the process bearable. We're not here. We're here to help you. You elected us to promote and protect your interests, and that's what we try to do. So don't be afraid when you come to court. It's not a bad place.
Oh, yes, it is. Stop playing.
For the civil stuff.
The other thing that I do is I'll talk to the defendant. I don't care whether they have a lawyer or not. And sometimes the lawyers will get miffed with me because I'm talking directly to the defendant because I want the defendant to know that we're here.
Exactly.
And I'm talking to you for a reason, and certainly letting you know what the situation is, because the attorney could say anything. But I tell them the bottom line is this is your case. You have to make a decision. Yes, you need to consult with your lawyer, but the bottom line, this is your case. And certainly it has consequences to it.
And it's your life.
Okay, let's get another question. Jump.
Hi. First of all, I want to thank all of you for giving us this opportunity to hear about the court system. My name is Sal Crumella. I'm a educator, especially in the medical field. I'm a philanthropist, a community leader, and I had a serious question I'd like to present. And that's why and what could be done about nursing homes, restricting physicians from doing the proper testing for their patients just to save money for nursing home owners and the insurance companies. It's an absolute crime.
I think you need to be asking that to the legislators.
Thank you.
Because
Yes.
certainly, I'm saying they set the standard. Is what they're doing right? I don't think any of us up here would say that that's right. That's like having HMOs and I'm not gonna speak too much, but the same thing, how they try to cut corners in order to save money, and it's not to the benefit of the people that they're supposed to be serving.
Absolutely. But I find it a complete crime because here these innocent people who are not getting the proper treatment just so that they can't discover. They're doing the minimal amount of testing so they can't discover if there's really a problem to keep them out of the hospitals, to save them money and all. And it's unfair. And I'm sure if it were your own parent or so, you'd be alarmed and up in arms.
Let me add one thing, being your surrogate.
Yes.
One of the things that I'm seeing is a lot of people go into the hospital and they don't come out. And as a result of looking at that, that's telling me that there's a real crisis in healthcare. Most of the cases that come through what's called our miscellaneous part, that's the part that everything goes into. I can't tell you how many death compromises I see. I can't tell you how many people that are young that are dying. And unfortunately, the death certificates don't even tell us why sometimes. So it's a real crisis we're having. And I mean young, I mean 20,
But this
30,
is all based
40.
on insurance
The
companies
health
having
care,
control.
that means that's legislative changes. I think
And
Judge Dowling
that's
is saying.
the issue that's not a question that we could answer.
It can't,
In terms
but-
of what happens if it comes to our courts, we have to deal with it.
Right.
But to say specifically that if you had somebody in your family who had this test to take and they did it, we can't get into that.
But if you feel that it's that pervasive, then you have to go to the district attorney's office to
Right,
present
to
what
make the
evidence
crime
that you have
happen.
that a
Make the
crime was
crime
committed. And that's how the process would work. It would have to be taken to the district attorney's office as a criminal case.
Yeah, but see,
then
now
to
you're
then
singling out one individual as opposed to an entire class action or a group situation that's going on. This is going on everywhere.
If you see something,
I'm
say
a
something.
consultant for the hospitals and for laboratories and so forth. And this is, we review everything. We look to see how this is happening. And it's actually a sin, I mean, let alone a crime. But I thank you for your advice.
Thank you.
Hello, everyone. Thank you. I came in late. Is there anybody there in family court?
Yeah, they kicked me out. What you want to know?
Stop saying that, Judge Sheares.
No, I'm telling the truth to the people. Stop it.
What's happening in family court?
They didn't kick you out.
I work with children who have mental illness, and they've been on AOT, assisted outpatient treatment. And what happens is they go to court, and the judges there are letting them out when they're not ready. They need to be mandated to be, if they're not doing the proper thing, to help themselves or save themselves. I see children and younger adolescents and adults, and I think it could be drug-related, marijuana or whatever, that cause the mental illness, and that's why they're on the AOT treatment program. Well, I noticed that kids are coming out and young adults are coming out that shouldn't be coming out. And what happens is that's when things turn to criminal. What can we do to fight for these kids? Because I have done that. And then I went to court with some kids and some adults and got thrown out too. Okay, I did, so, and they weren't ready. So what is the next step when you know the people are not ready? Because the way I see it, they're bound to be I'm gonna keep it real, 6 feet under in the hospital or dead or back in jail.
So I'm going to try to answer your question because a few years ago, I presided in the mental hygiene part, and now I do all of the appeals. In fact, I have an AOT. AOT means assistant outpatient treatment, where an individual has been diagnosed with a mental illness, has had several crises and several admissions in a hospital, but now, under a court order, after a hearing, this individual is mandated and ordered to attend certain therapy sessions, see a social worker or psychiatrist, take medication, report twice a month to a counselor. This person is under court mandate to comply. Now, there are times when these same individuals are in denial and they're saying, I'm not mentally ill, I don't need to be supervised, I can take my medication, I can care for myself, and then they go to court and try to get the AOT mandate vacated. And I have to agree with you, sometimes they need to be supervised under AOT. Other times, you have people who have a history of being compliant, taking their meds, meeting with the social worker, doing everything right. They've been doing it for 10 years, and yes, they need to be off. But then sometimes once they're off, they think, okay, so I'm independent, I'm now gonna stop my medication, and then they start to deteriorate and they come right back. There's really no easy answer. All I can say is that when you say they're not ready, are you saying they're not taking their medication, or what do you?
That's part of it. Yeah, mainly that's part of it. But I see things that they could end up in jail, criminal offenses and stuff. Some of them got criminal minds. You know?
Well, okay.
I don't know what else.
Could I just add something along the lines? I had one defendant who was riding on the train who had a mental problem, and for no reason, this woman who was in her late 60s, he gets up and he kicks her in the face. Now, he needs help. We all know he needs help. His attorney knows it. The district attorney knows it. And we're trying to find a program, but there's no program that we can get this man into that will accept him. So, to me, you know, and we're trying to work something out, but the bottom line is, and he knows he needs to help himself. And we're trying to find a program, but a lot of times there is just no program to get this person in who needs the help, because at least he acknowledges it. And sometimes what happens is that the attorneys will then, I'm gonna put it all out there, they may say, well, I don't want my client to do X, Y, and Z. Well, I don't want my client to enter a guilty plea if that's gonna get him, you know, the treatment that he needs. And I've heard them say that, and I said, well, if the mother wants help for him, well, this is not his mother's case. You know, and the mother certainly would have the best interest at heart for her son than anybody else. So, you know, it's really a balancing act, and sometimes our hands are tied. Where do you go and what do you do if you're trying to find a program for a person who really needs the help but can't get it?
All right, thank you.
We try.
But that's mental hygiene too, Judge. Thank you, Judge Wade. Next question.
This question is towards Judge Thompson, Surrogate Court?
Yes.
Okay. Can't hear you.
In the question of a death, a natural death versus something that may be questionable, who is responsible for paying for an exhumation fee? If you needed to exhume a body to have an autopsy done if one had not been done?
I didn't hear what you said. Who
would pay a fee to exhume a body if there's a question of the death?
If it's criminal, I believe it's the medical examiner, and you have to put in the request through them. I can't say that I've dealt with that issue, but I do know that there's a lot of new ways to do DNA, and that has I'm starting to see that more and more, but I haven't had that particular issue. Most of the deaths that we have come through are natural, or we know that they're medical malpractice and things like that. When you start getting into the criminal area, that's when those things become free. Because remember, that's the obligation of the state. But if it's anything other than that, it would be the obligation of the family if that's something that they specifically request. And they're expensive, the autopsies.
As to
Very
what the
expensive.
death certificate states as the cause of death.
Right, because it is a question of the state and the inheritance, and this particular person's relative died within 5 days of returning to the U.S., and because of the religious faith, was buried, and none of the
Right away.
Extremely right away, within a day. And the family members didn't have a chance to have an autopsy, see the body, go to the funeral, and they're now in surrogate court with the person who allegedly married that person who is deceased.
We didn't see that a lot. I had one guy, She married him, and he died 2 days later. So the question had become, was it intentional? And I believe that particular family did, in fact, contact the homicide, and they're dealing with that. Yeah. So,
Okay.
you know, it comes from different ways, but it's a very good question.
Thank you.
Thank you.
Hi, good night. My name is, I'm probation officer.
Come on, step on up.
Oh.
Step on up to the mic,
I'm probation officer Morgan. I work right across. This question, I'm going to piggyback on what this gentleman said regarding the collateral and certificate of relief, and when he's on probation. I don't know if he was on probation, but he was on probation. But my question is, how can judges alleviate the anxiety of clients coming into court, especially when they're given probation and they have to sign a condition of probation that they do not understand? As Judge Walker explained, he's take his time and explain it to the youth and ask them if they do understand what educated youthful offender means, and explain it to them. For the other judge, because I have a lot of clients coming in, which I receive cases from all my Supreme Court judges and criminal court judges, and when I get them, because I work in intake department when they first come on probation, and the first thing that the probationer says, oh, I don't know what, I don't know, it was the rush, and which I can understand, because you got the ADA, you got the judges, you got everybody in the courtroom, and this is being said, and they're not being explained the condition of probation, so they come all confused and be like, the judge didn't say that, the judge didn't do that. So how can we alleviate that problem coming on probation to see to be assigned on probation?
Well, let me say this, that certainly if probation is a condition and they need education, they need other kind of counseling or treatment, I tell them, listen, and certainly with the probation office speaking to them, they will have a more in-depth idea of what the person may need. So I tell them, probation is a privilege, it's not a right, it's a privilege that you're being given. You have to follow all of the terms and conditions set by probation. They say you need education, then you have to go to school. They say you need a program, then you have to comply with that. But you don't get to pick and choose the conditions that you're going to comply with and those you won't. Because again, with the probation officer working with that individual, they would or should have a better idea whether they needed vocational program, educational program, or whatever, if they need some other kind of counseling, where they should go. But I tell them that they have to follow all of the terms and conditions and not get to pick and choose. Those they will follow and those they won't. Because sometimes probation will impose a curfew, and if they believe that is in the best interest of the probationer, then that's what the probationer has to follow.
And we're not rushing. I mean, what I could say is, you want to speak for yourself, but I do know my colleagues that are up here is that we are taking our time. We're very thorough. Nobody, it's our courtroom. Nobody is rushing me. And it is important that, because I'm elected, but I'm from this county. Right, we're born and raised here. We live in the community. Our families are here. This could be somebody that could be my own family member that's before me. So I afford the people that come before me the same information as if it were somebody that's a member of my family. You need to know what it is that's going on. So I mean, it is an overwhelming process. And it's the first time that you may be hearing the probation terms, and they are explained to you. But listen, if you're new to any environment, sometimes you're grasping things and sometimes you're not. When we step out of our comfort zone and we're put somewhere else, they'll say you're taking care of, we have your elderly parents or loved ones or aunts or uncles, and then you're put in an environment that's outside of our comfort zone, and then information is flying to us. Sometimes we're like, well, what is going on here? You have to, so we can relate because we're people too. That's really what I'm trying to say. We're people too. We bring those experiences to the bench. As myself and Judge Thompson were talking about, that's why you need to know who you are electing.
Please tell them that. Did you hear what she just said? Did you hear what she just said? You need to come out and know who you're voting for and not just let a district leader or someone else tell you who they are.
And let me
There's
just
people
say,
now on the bench that shouldn't be there.
and let me
Our
just
community
say,
has been sold out. Know who you're voting for.
Because we
Don't
work
just
for
read their
you.
literature. Come out and ask them questions when you see them. Let me
Yes.
give you a good example. I'm sorry.
okay. So, I know she will give you an example, but before you give the example, I'm gonna come back and let you give your example, but just,
No, I'm
and
gonna
let
leave
me
that
just say
example
this
alone. Let me
for
leave. You saw me
people
getting hyped.
that's on the civil side. The same thing applies. When you come in court and you sign in those stipulations and you sign off on them, I don't know about what any other judge does. But again, y'all, I'm gonna keep saying this probably, but I work with Judge Dowling. And Judge Dowling used to go over those stipulations ad nauseum. And attorneys used to be so angry, right? However, now when the people come back, they can't say that nobody explained it to them when Judge Dowling's name is on there, because everybody knows that Judge Dowling explained it, right? So I learned that from Judge Dowling, but then I took it another step and I asked, what did you sign? So I make them tell me what they understood.
Excellent point.
That they signed. Because I could read it to them and I could say it, but if they don't understand it and they can't tell me what they signed, it's a different story. So after they tell me and it makes sense to what they signed, I write on the bottom of mine, read, explained, understood, and agreed. And then I sign my name. Another thing, as you would say, that people come and they anxious, they afraid, or whatever. We know that. I'm in civil court, I say to them, and as Judge McAllister said, most people come through civil court are not represented by an attorney. So I will say, nervous? They say, yeah. Or sometimes they go, Judge, I'm nervous. I'm like, okay. So go outside or have a seat, get yourself together, 5 minutes. And when you come back, pretend as if you have invited me into your living room. Just don't take your clothes off. Right? So now they laugh, they know the judge have a sense of humor, and then when they come back, you'll be surprised how now they are able to say to me exactly what they need to say without rambling, without being nervous. You gotta try different approaches. Everybody is different, and we have to do what we have to do to make it happen. And this is an example of what we do to make it happen, because you remember Sims used to have a commercial, an educated consumer is our best customer. So when you come in and you know a little bit, at least not to be nervous, at least not to hide the papers, you're better. You're making our jobs a little more.
And if you ask questions.
Ask questions.
You know, despite what the attorney may say, excuse me, Judge, my lawyer said X, Y, and Z. Is this, get that information.
Next question.
Thank you so much for being here and making us see that judges are approachable. My name is Marcia Ziegler. I'm a power of attorney for my mother. This is a foreclosure issue. The issue is that there's a guardian ad litem that's attached to my mother's attorney, although I was the power of attorney prior to this happening. It's apparent to me that the courts and the attorneys got together and decided to have a guardian ad litem put in place to deal with my mother when I'm her power of attorney. I would like to know, what can I do about that situation?
Okay, I don't know if you were here when we first started, but one of the rules is we cannot talk to you specifically about your case.
Okay.
Okay, so if you could talk about it in a generics, perhaps, but otherwise we can't talk specifically about your case, an ongoing case.
Okay, can't even be hypothetical.
It's out the bag now. It's out the bag. It's a no-no now.
Dr. Jotley, do you want to deal with that one?
I can't, as Judge Sheares indicated, speak specifically to your case, but you have a power of attorney. I'm going to use an example of cases that involve the POAs, and whether it's another relative or someone else coming in to question that POA, and I don't know what type of POA you have. It may have been limited. I don't know. You may not think so, okay? And I don't know why your person, meaning the mother, put you in charge for whatever specific reasons, but the house is in foreclosure now. And so you have the guardian ad litem who was appointed by the court for a reason, and something is up with the POA. And I just have to tell you that. It's not just overlooked all the time. And if you believe that your power of attorney gives you the powers that you need to handle your mother's business, but yet you're not being allowed to do so, then my suggestion would be get an attorney to fight for your case. What you believe you should have already the power of attorney to do.
Okay, thank you very much.
Thank you, judges, for this forum tonight. I'm glad to be here, and I'm getting a lot of information. My question is on will and trust. Is there a difference between will and trust? And is there anything as irrevocable trust? What are the differences?
Yes, a will can contain a trust, and it normally does. And I think I would say it like this. The will can dispose of the property through the trust. So it's like a bucket that you decide you're putting everything in. Somebody administers it. They determine, there's going to be distributions through it. So most of the time in what I've seen, and I do have my court attorney referee here, Meredith Jones, it's usually a will that contains the trust, which deals with the way that the property can be disposed of once the decedent or the person who did the will, them passing away. There are many different types of trust: revocable, irrevocable. You have special needs trust. It's just a vast area. And I think that's the easiest way to explain it. That's the easiest way to explain it.
Is one better than the other? Is the will better than the trust?
I think it depends. It really depends upon the type of property. Real property, stocks. Was it already a trust that was part of that was outside of the will that's now made part? You have so many ways that people deal with that. That's really a whole conversation in the area in and of itself. But I think that no matter which way you decide to dispose of the property, it should be in writing and not have the state of New York determine it through intestacy. That's the important point. And then when you do estate planning, depending upon the type of property, where the property is located, foreign, domestic, right? The type, if it's mutuals versus securities, all of those things matter as you put them into the pot, because they have different legal consequences, different tax consequences. So I think estate planning is just that, planning based upon what you own. You may not want it in a trust. You may want it in a trust. You may want a lifetime trust. You may want it in the will. So there's a lot of different considerations. That's why lawyer, 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 and one that does that for a living, not the one that does real estate, the trust and estate attorney, and that does estate planning.
Okay, good. Thank you.
And on that note, that's a very good thing that Judge Thompson said. When you have an issue, go to that type of lawyer. Okay, so if it's trust in estates, you go to trust in estates. If it's landlord-tenant, you go to a landlord-tenant. And let me just say this for all my commercial business people, go to a landlord-tenant attorney, real estate, who knows real estate and commercial landlord-tenant, because commercial landlord-tenent is certainly different from residential landlord-tenant. So be very specific about your attorneys.
I'm going to add one thing to that. You know, one of the things, I was in private practice for 27 years, mostly. I had little state service. You can just get referrals. Talk to people. Do you know a good lawyer that does this? Do you know a good lawyer that does that? And if all else fails, the Brooklyn Bar Association will give you referrals of people on their list that at least they know do that area of practice and that are competent. A lawyer's not a good lawyer if the lawyer's not competent. Would you agree?
True.
There you go.
Thank you.
There are certain aspects of the law that really require specialization, criminal and matrimonial.
Yes.
I mean, criminal, you just can't have someone who does everything. You're dealing with somebody's liberty. And you're also dealing with somebody's money and and everything that they've worked for. So you want someone who has that specific expertise.
Next question.
Good evening, everyone.
Good evening.
I'm a clerk in Brooklyn Family Court, so in my experience, I know that the courts, you discussed a lot of the serious business of the courts this evening. However, the courts also welcome the public for a lot of free events that are educational, social, entertaining. Sometimes they offer refreshments. So can you please discuss some of those programs where the public is welcome to come into the court, not for the business of the court, but just to feel comfortable, to learn, to interact with the judges and the advocacy agencies, and perhaps not be as nervous when they enter into those buildings?
Well, I will say that courthouses are open courthouses. They are the people's courthouses. So you are more than welcome to come into the courtroom at any time. As long as we're open for business, you can come in and you can sit and observe. And I think it's important for everyone to do that. Just as it's important for what you're doing here, and you're coming in and you're getting this information from us, it's also important to actually see what goes on in these courtrooms. Go to housing court, go to civil court, go to matrimonial court, you know, go to criminal court, sit in an arraignments at nighttime and see what actually happens at that particular time. I know for my court, I have classes. I just had a 5th grade class come through 2 weeks ago, and I constantly have high school students that will come in. I'll have college students that will come in. I'll sit them, I'll put them in the jury box so they can observe, and when we have a break in what we're doing, I actually get off the bench and I go and I talk to everyone and I explain to them what we're doing here in the courthouse. Because again, I think it's important to demystify what people's perception of the court is, you know, and so you already have taken a very important step by just showing up here today. But that's an excellent point that you pointed out, is that the courts do put on different events. We put on Black History Month events. We put on, you know, Hispanic Heritage Month events. These events are open to the public to come in, and not only to go ahead and explore the heritage and the things that go on in the courts, but also to learn about the courts and see who's inside the courts. So,
And
thank you.
we take the time to talk.
Judge Dowling is the co-chair of the Black History Month Committee, which I'm very prejudiced for because because that's the best Black History Month program in the world.
Well, I'll go one better. It's the best program, and I'll tell you why. It
In the
is
world.
open to the public. And those people coming into the courthouse, we also publish our calendars in the Brooklyn Eagle, when they're kind enough to publish it for us. And the events are there. They're educational events. It brings you into the courthouse. It gives you different information about different things. As part of the Black History Month program, we do a health component. And 2020 is the year of the African Americans and the vote. And so we're concentrating on the vote and also the census. So I'm telling you, it's gonna be a powerhouse, and we try to educate. And this year, we have programs and I think every one of our courthouses in Kings County. And we've even done outreach. We expect to go to the youth court and Red Hook, the community court, and also sponsor a program. So we are doing things, educational things, and we want to get the youth involved in that aspect to find out how the youth think, what's the importance of voting, because we can talk about it as adults, but we want to know how they feel about it and how they view things, you know, from their perspective. So again, we try to do more outreach. We can do it better so that people know when you come in. Certainly there are programs to be had, because I know they have mental health programs that they offer, but it needs to be more widespread. It needs to be such that everybody know that it's an open door program and that they can come in. And I will say this, that we had 3 ladies who must have been in their late 70s or early 80s. They came for jury duty. And Black History Month program that they were saying they didn't know about it, and they came the entire month and planning on coming next year as well, God willing. So again, it's open. You want to be educated, you want to learn something, you want to be entertained. We have all of that going on. And certainly the Brooklyn Eagle will be publishing a calendar at the appropriate time. I'm hoping I get that commitment from Rob.
You want entertainment? Come to me. 961, 360 Adams Street. That's my courtroom. It's
But
never,
you all
never
just,
quiet.
If I'm not mistaken, Italian Heritage, you just completed that. Is that correct, Ms. Judge Ciccotto?
We just had the Italian, I'm Italian American, actually Sicilian American. We just had Italian History Month. But it's open to everyone, because you know something, we all are different, we all live together, and it's important, and it's actually delightful to get to know each other and each other's cultures and the things that we do. And of course, we always get, when there's food involved, it makes everybody happy. And that always has a way of bringing people together.
And on one other note, we have a wonderful, again, one of the best, if not the best, summer youth employment program, where we hire young people from the Department of Employment through some of our providers. So we are human. They don't zap us up and shoot us down like Scotty at the end of the night in the early mornings.
And we also have mentoring programs, like the Brooklyn Women's Bar Association initiated a mentoring program. And I personally don't always take law students. I like to take, for interns, I like to take high school students, because I think that's the age when they need to make decisions that are important. You know, a law student, well, we already know that's a prospective lawyer, but when you get a high school student who's really not sure what they want to do, and to bring them in different aspects, and I prefer younger interns, and I will send them to different places. I will send them to arraignments to see. I sent one of my interns to see specifically Judge McAllister do arraignments, and you send them all different places, so they're getting a wide view of things. And I think the younger you can get, could get these folks involved, the better it is for them, because that's the age when anything could happen, and that's the age you want to help direct, focus, guide, and advise.
Okay, we're going to go to the next question only because we want to get everybody that's on the line now. Okay, next question.
Good evening. First, I'd like to thank the judges for coming out and sharing their expertise and professionalism. And like my students, I don't have one question, I have 2, but I see the line is long, so I'll go with the one I think is most pressing. And I heard you say that you can't talk about a case that's actually going on, but this one I've been reading and following in the media. So I won't reference it specifically.
Okay, let me say this and ask the question, because this line is long, so just ask the question. You can give your name, then your question.
My name is Gail George.
Question.
If there's a case wherein the behavior starts out minimally trained surfing, but it continues to escalate into the point where it's violence, where people being pushed onto the train track.
Push back from the mic.
Pushed onto the train track. Why are people being recycled through the criminal justice system over and over again, when obviously it's a mental health issue? And does the mental health component or criminal justice, do these agencies collaborate together? Do they talk? Do they network? Do they look at these cases collaboratively?
as I said, as a judge, you may know the person needs help, but what program do you put them in? And certainly that becomes an issue. And if you think it's an issue now, you wait until January 1st, 2020.
I can imagine.
It's going to be even more of an issue. That's all I'm saying, because there are a lot of different components, and you try to get people the help that they need, but where is the program? They're talking about different things and shutting down different things. Well, where is a program for people who have mental health conditions?
None.
Because certainly, even if they're admitted to a hospital for 30 days for observation, after that 30 days, more likely than not, they're back out on the streets. Right. So I'm saying, you know, the judge is only a small cog in the wheel. You can try your best, but I'm saying certainly, and people get up in arms, you can't hold them in jail, because they're being deprived of their freedom, okay, and then people are saying it's wrong to do so, and it would be wrong, because if they need help, they need help. So I'm saying that's where the other services come in, where you have the city stepping up, or the state stepping up and saying, these are the programs we have for people with mental conditions, and this is where they can be sent for mental conditions, for medication, for housing, for whatever it is. And to have that component there, we don't have that safety net to prevent a situation like you're talking about.
And just to,
And some of them work, some of them don't.
well, I can project.
Okay.
There we go. Just to talk about what Judge Wade also touched upon. Remember, she said some people are medication compliant. So as long as they're taking their medication, they're fine. But what happens when they stop taking the medication, right? And again, we incarcerate more people here in the United States than any other country.
I know.
Right? So incarceration in and of itself is not preventing people from committing crimes. Also, mental health is a big problem.
Really is.
It is a huge problem. But you cannot lock someone up for their entire life because of a mental health issue. And what happens when they are incarcerated, they're not getting the medical services that they need either. So what happens is that they do a determinate sentence, they come out, sometimes worse than what they were when they went in, and unfortunately, these things happen as you see. And of course, they want to point the fingers at different individuals. But we need to have comprehensive mental health care. It's necessary.
True. That's the issue.
That is the issue. That's the real issue. It's unfortunate, but that's the real issue. Incarceration is not going to solve a mental health issue.
And we need them funded.
Next question.
Thank you.
Okay, can everybody hear me?
Yes.
Okay, my name is Wally, and
Can you all hear her in the back?
okay, my name is Wally. How about now?
Yes, go
Okay,
ahead.
and I run a tennis association in Brooklyn North, and I have two questions. I think they go together. One is about the lease. The landlord provides the lease only in English and some parts in Spanish. I have a lot of residents that are Polish, and I have to go there and get a translator from English.
What's your question?
You know, is there anything that we can do for him to get it for everybody's language? You know, and another thing is, we used to pay the rent downstairs. Now the rent's going to Jersey, coming back to Queens. And I'm disabled, and we have a lot of people who are disabled. Is there any way that we can get him to get the rent like we used to pay there, instead of going from New Jersey, going back to Douglaston? And the lease being in, you know, in different languages for the tenants, because I only speak English and Spanish.
You want me to take that? I think it can be done. I think you can request it because you're a special building. And I believe that there are certain legal publication places that provide it, but it's going to cost. So I think the most important thing to resolve all your issues, you need to form a tenant association and make demands. Okay, so you need to make the demands of the landlord. If the landlord doesn't respond, then you go to the next step, right, which is the state of New York, Division of Homes or Housing, the same thing, and Community Renewal, and file a complaint and make the request. Okay?
Okay, thank you. And that goes for both, for the lease and the rent?
I believe you should do both.
Okay.
Because they've changed the method of payment. And normally, under the rent law, the way things were at a certain time, it's a different issue, but it should remain, particularly if it affects people such as you that are handicapped. You should ask for an accommodation for your handicap, right? You could go there too.
They won't do it.
But remember, action. You gotta do action.
Okay.
You just can't say no. Sometimes the people that get to the end are the ones that endure to the end.
No,
You just can't give up.
All those processes I'm going through.
Good.
But I'm
Stay
fighting for
on
my
it.
tenants. I'm fighting for my tenants.
Stay on it, but it's not just you. You need others behind you.
I do, we do.
Petitions, go to state, and then if you have any other problems, come on down to the housing court. We may be able to assist you there.
I was gonna say, but not only that, if you have your local legislators, you should also be going to them.
I have gone to them. I've gone out of my district to get help because I'm not getting help from my, like the judge said here. I have county committee and stuff like that.
Good.
I'm involved with my community.
Good.
I go to high schools. I'm very involved with
So
my
that
community.
means that you can help make change.
Oh, yes.
Stay on it.
I am.
Next
Thank you.
question.
Good evening, everybody.
Good evening.
My name is Michael, and I've been a practicing attorney for 20 years in civil part. And my question is really, when we come to I was just in the part of one of the judges here today, it's, it's like coming to a deli, take a number and wait. It's, the courts are very overburdened and frustrating for lawyers. I'm sure it's frustrating for the judges as well. My question is, what do you folks do? What is one, or I don't know if there's a silver bullet for this really, but what are some of the things that, whether it's you personally or in your chambers or within the system, that's being done to lessen the burden? And what is it, and the other part is that, what is it that, and a little bit more practical from my standpoint, is it, what is I, as a lawyer, or any of the people here sitting pro se, can do to help themselves to move the case along from your standpoint?
Well, I don't have a meat market or whatever that deli, take a number and sit down approach in my courtroom. Everybody gets in. And my problem that I have is that I may have one side, right? I might have the petitioner, I might have the plaintiff, but I don't have the defendant or the respondent.
Right.
Right? So if we give you a time to be there, and if everybody comes when they're supposed to be there, then you go. But my problem, again, is getting two parties there at the same time, especially in civil court, especially when you have the no faults, because then you have the attorney that's downstairs in the trial part, and then the other part that's the same attorney who's doing all the motions for the day, where there could be 200 to 300 motions on the calendar. So I know, as somebody already said, we always want to say whose fault it is, but sometimes it's civil court. If we act more civil toward one another, we can work that out.
Thank you.
We try. In matrimonial, there's only 5 of us. So invariably, we have to wait till everybody goes. I waited this morning for someone who had a hearing before one of the judges. It was a final date. So, you wait and you try to accommodate, particularly if, I was a practicing attorney. I understand that you're not an octopus with 35 arms and you can't be everywhere. So we also have to be courteous to our colleagues, too, and determine, where is the need? You need to do this first? Well, I'll wait. And we do the best we can to facilitate things.
I think there's another issue, too.
I was going to say also, in terms of the number of cases that judges are assigned, we do the best with what we can. And I know that there have been times in my courtroom, if I'm busy doing a hearing and a person comes in, well, you see, I'm not sitting twiddling my thumbs. I'm actually in the middle of a trial or a hearing, so you have to wait your turn. And sometimes attorneys, when they come into a courtroom, they want everything to stop in the court to call their case right away. It's not possible. So we all have to work together. And certainly if there's been a person in the audience waiting longer and their attorney comes, I'm going to call that case before I call your case, because the litigant has been there waiting.
Right.
And I tell attorneys also, they keep their clients waiting all morning. I say, counsel, your client has been here all morning. I'm saying we were waiting for you. So certainly that's unfair to keep your client waiting all morning also. So there's a lot of moving parts. We can get it done, but we all have to work together.
Yes.
That's the bottom line.
It's a collective effort, and I've been known to pick up the phone and call attorneys just to ask where they are, so I can tell their clients who haven't heard from them what's
Where
going
they
on.
are. Let me just make one point, because you can tell I'm the rabble-rouser. But I think it's important for all of you to know, and this has been my feeling. I've been in this borough since 1983. Brooklyn has always been treated as the stepchild of the judiciary.
That's correct.
And unless you guys go and make an appeal to your legislators, the councilmen, the hierarchy in the court, we need more judges in Brooklyn. It's as simple as that.
Absolutely
And if you
true.
don't do something and say something, nothing will happen. We could tell them we tired, we working, because I was in the civil court for, 8 years? And, I mean, it's really gotten to be onerous. Do you agree, Judge Sheares, where you're doing back-to-back? Come on.
Always.
Come on, Judge.
It's everywhere. It's the criminal court, it's
No,
everywhere.
I'll tell
It's
you
everywhere.
about needing more judges. We are well overworked in the civil court. We do rotations of circuits. As I explained to you, we have a circuit of 4 weeks. We do 1 week small claims, 1 week commercial landlord-tenant, 1 week no fault, and
How many back-to-backs you done did?
I was only supposed to do 5 this year. I think I've done 7. I'm going to go on 7 now.
Did you hear what she said?
Because
7
we
full
don't have
weeks at a
enough
time,
judges.
nonstop.
And you have to help, and you have to get the work done, and we all chip in and do what we have to do.
No, and I really meant to salute you folks, because I know that some judges have gone to like 3rd calendar call, for example, because they really are reluctant to call people in default, and they really
Right,
are
because the
trying.
case will just come back.
Right,
Right,
exactly.
exactly. But,
It'll just come back.
And
One of
you
the
know,
problems is some people do not come to court on time.
Right.
Got to get to court on time. That's why you have a large number of people who have to come back and file orders to show cause to get their case back on the calendar because they defaulted, they didn't come in.
And tell us if you need to be somewhere else.
Exactly.
On an emergency basis.
Exactly.
Pop your head in and say, I need to be somewhere. So we know you're there, we put your case on the side, and we wait till you can come. No one wants to default anyone, because if we default you, who suffers? The
We-
client.
and
That's
exactly.
not what we want to do.
And
So-
we were attorneys, we understand that sometimes you have 3, 4 parts you have to cover. We understand.
So
Just
I was-
let us know where you are, and it's really not a problem.
So
Thank you very much.
I was just going to add, sir.
Yes.
Counsel, I've seen you before. I'm in the Supreme Court. I'm an acting Supreme Court justice, and I do a lot of medical malpractice trials, and the trials can be up to 3 weeks, but still during that 3-week period, I have motions every other Friday. And sometimes I have 90 motions. And the key is being organized. We have 2 calendar calls. So in the first calendar call, we mark everyone who's ready, we get the motions together, and then we have a second calendar call maybe an hour later. But we take the ready cases first. If we call a case and all parties are not here, we just put it to the side, next ready case. We try not to default anyone. I hate to default people because it makes the client come back. We have more paperwork. But to us, it's organization. And we know you're in different parts. All we ask is that you leave your cell phone number so that if we call your case, the judge can reach you or the clerk can reach you so that we can try to dispose of the matter in a timely fashion. Because close to 90 motions, that takes sometimes all day. It's not like no fault. These are summary judgment motions. But the key in our part is being organized and keeping people in communication with each other. We don't like it when you come late, but things happen. We understand.
And in certain parts, like matrimonial, the attorneys are getting paid by the hour. These folks are missing work. So I have to consider that folks are missing work, the attorney hasn't called them, hasn't checked in, and the time is going. And the time is going, and folks are paying, and they're not going to work. So, you're also concerned about the clients and the litigants. I see an attorney that doesn't show and hasn't had the courtesy to call the client, then I get very angry, and that's when I pick up the phone, because I want to know where you are, because your client is sitting there. And a lot of these folks don't necessarily get paid for the time they're there. And somebody that's waiting till 11:30 may not be able to go to work from there. So they ruin the whole day.
The courts are always, we're aware of the problems, and one of the things that has happened in 141 Livingston Street is that because of the congestion in trying to get through the magnetometers and get to the parts, what we've done in the housing court is have staggered calendars. There's a lot of resistance from the attorneys with regard to the staggered calendars. People they resist change, and, you know, but we have not had late lines going past default times since that's been instituted. So it's a constant process of looking at the situation and trying to improve it.
Thank you very much. I just want to add that I consider myself a warrior for my clients, and the folks here are the people who come to you. So I agree with you completely. Lawyers who don't come and work for their clients, you know, are not worth the full.
Thank you.
Thank you. Let me say, I see all judges looking beautiful up there, and listening to you, it would be nice if all judges would be, the feeling I got is that you truly are concerned about those who come before you and try to give the right justice. But sometimes we find often the best liars win, I find going on in the world today. But my question is two parts. One regarding mental hygiene and foreclosure. I came in, only one judge I did not hear introduce herself is the Judge in green? Yes, is it on foreclosure? Anyone here?
Just ask your question. The judge will have to answer.
Okay, all right. What I want to mention regarding mental hygiene and piggybacking on the lady who spoke earlier about mental hygiene, what I found is that there are certain...
What's your question, not what you found?
Oh, okay, the question is, well, now I have to try to rephrase it, but regarding the treatment, I know of a situation where persons are discharged from hospital mental hygiene, go to AOT, then they change the medication quickly. So it's just throwing the patients into deeper situation. And it's a matter of what I find is trying to make the patients compliant with the program to fit the requirements for the program to keep that volume to keep a certain number of clients in that area.
What's the
so
question?
What I want to know is if there is anything regarding if there's any support system to sort of double check if the patients are receiving the right treatment, regarding to the quick changes in medication that's allowing certain patients to be in, like revolving doors, in and out of the hospital.
Okay, so I'm not really sure I understand what your question is. However, let me just say this. So when a patient is admitted to a psychiatric facility, usually they're evaluated by several psychiatrists, and depending on their history, meaning whether or not they were diagnosed in the past or whether or not this is a new diagnosis, the doctors will treat them based on the symptoms that they exhibit. Now, the issue of compliance is always an issue of compliance, especially when patients are taking oral medication. But sometimes when they stop taking the medication and they start to deteriorate, the doctors may say, okay, we're gonna try an injectable in lieu of oral medication because they may be more compliant. There's no exact science, it's usually up to the psychiatrist. But if the patient is not happy with the medication, they can apply to the court for a hearing to have their medication either changed or to have the medication discontinued. We have to have a full hearing with the psychiatrist and the patient has to be represented by an attorney before I can rule.
Right, but that is true, but I guess I did not make myself very clearly, but what I'm talking about is
Okay,
here.
let me
They're
give you,
discharged
let me
from the
tell
hospital.
you. I know this is a question, Judge. Because I heard what you said, and I heard, and if I didn't, then now you say it, okay? She's saying that a patient is discharged from the hospital with medication A, right?
Yes.
In compliance, all of that.
Yes.
But then the facility, the doctor, say, no, you're supposed to be taking medication B
Well,
because...
that doesn't make sense. If you're discharged...
Listen to me,
Okay.
what she's saying
Okay.
is that she thinks that the doctor or the facility is just doing these changes because they want to keep people in keep their pockets full.
Oh, okay.
Right? See,
Okay.
Okay, she
You
broke
mean
that
they want
down.
to, okay, so I've heard that from other people. I've heard, they mean keep like control over an individual via medication. Is that what you're saying?
Right.
We hear that sometimes in court. We hear that. But usually when we have a hearing, we have 2 psychiatrists, and these are medical doctors who specialize in psychiatry, and based on their experience as psychiatrists, along with the symptoms that the patient is exhibiting, they determine the amount of medication, and I have to determine whether or not I believe them or not. I always let the patient testify, but usually when the patient testifies, it's never, they have an attorney, but it's never rational. So if it's not rational, then I'm gonna think this person is could be a danger to himself or others without any medication. So it's always a burden. It's by clear and convincing evidence that the judge has to listen to the psychiatrist, 2 of them, review the medical record, the psychiatric records, listen to the patient and his attorney, and make a determination. It's never an exact science.
I understand
I
that,
was
but
gonna say, well, let me say this. If you feel that the doctor is just giving different medication for whatever reason, then you have to be your own health advocate. And if you have somebody who you know has a mental condition, then you need to have somebody go with them so that they can break it down, because we know sometimes doctors can be dismissive. They will say the person who has a condition they don't want to listen to. But then you have to have somebody to be their advocate to say, listen, doctor, you gave my brother this medication and it's not working for him. In fact, he has the same or more psychoses than he had when he came in. So why are you changing the medication?
Or-
And if it's not working, then put him back on the medication he was on previously. But it's not working. But you do need to have someone who will advocate on people's
Right.
behalf.
Or you can get a second opinion. You could get a second. You want the court. You can ask the court to appoint an independent psychiatrist to evaluate this patient. You could do that.
yes,
Okay.
but even though more specifically is they come from hospital, one set of medication, go to the outpatient medical unit program, and they change the medication suddenly. This was working, but now they switch
She
it.
just answered that question.
Okay, great.
And also, can I just say one more thing? You said that the old medication was working. Keep in mind that sometimes the medication is changed because of side effects. The old medication may have been working, but if this patient is exhibiting a lot of side effects, like, irregular movements, gets diabetes, it's a lot of side effects with these medications. Maybe that was the reason why it was changed. It's a lot of reasons.
And that is
But I hear you.
understandable, it has to be, but in this
I hear
case,
you.
none of that. You can
Okay, but did you hear what Judge Dowling said?
I got it
Okay, so
clearly.
long as you got it, we
But
have
they get
answered your
stuck.
question.
Okay.
Next
All right,
question.
next question is, someone give me a slip to say that there is mental hygiene first aid kits available at some churches and government locations, so people can check that out. Regarding foreclosure, I stand corrected. My understanding, when you take a matter to court, you take someone to court, you must file original papers to prove your case. I would like to know why in foreclosure cases they have, seems like 100% of the foreclosure cases that are filed, they have copies of notes and mortgages, and they're mainly filed by third-party lenders, investors who are not the original owners, and then the best of my understanding, the notes are sold on the stock exchange, and they're foreclosing barely on a mortgage when I understand it's a marriage. Not even a marriage, you can be divorced, but notes and mortgages, I understand, cannot be separated. But key question is why the courts are accepting copies of notes and mortgages as proof of evidence that these so-called lenders, or those who say they are the plaintiff owners of these notes, and they're accepting this. And my understanding is you must file originals.
You want me to take that
Prove
one?
your case.
Judge Thompson.
I sat in the foreclosure part. So the court will accept anything. However, you have to have a lawyer to raise those defenses. If you don't raise them, then they're not raised. But they're going to take the papers. It's up to you to not go down there without an attorney. It's up to you to retain counsel. And once you retain the attorney, once again, that does that for a living, right? That does real estate foreclosure, which was what I did for a living. It's the attorney or you going to the pro se office in the court and having them assist you in raising those defenses in your answer. And you remember what Judge Sheares said in the beginning? Don't just get the papers and ignore the papers. You've got to do something. You got to answer it.
But what of cases in which months after you learned about that there's a case pending, and
You
now
can still go in and do an order to show cause to vacate any kind of default which says that you didn't come. You can always do that. Doesn't mean you're going to be successful, but you have to bring the proper motion to be able to deal with that type of relief, which means to vacate and set aside whatever judgment that may be entered against you.
Thank you very much.
You're so welcome.
Good evening, everyone.
Good evening.
I'd like to thank the panel for being here and educating us on the various aspects of the judicial system. One comment is a pity we didn't have the names of the judges, that we can just look up there and see who the judges are.
What was that?
She said that there's no name.
Yeah.
Thank you for the suggestion.
Yeah, that's a good one.
My question pertains to housing court, and I would like to find out if there is a certain mandate or law that allows housing court to accept orders from a supervising agency when a case is presented to them in landlord-tenant court. Why judges don't accept the doctrine of laches as a defense, or repairs as a counterclaim? And also, why do they take months to make a decision after trial? And are they familiar with the new laws pertaining to rent, to tenants?
I have to say that the new laws are a multitude of laws that were enacted on June 14th, 2019. And it's a process. It's not something that we can learn overnight. It is a very big volume of laws in many different areas. And in a lot of instances, it would not be settled until the appeals come in and the appellate courts say what the proper interpretation should be. What was your other question?
Why the doctrine of laches is not being allowed to be used in the court, and why repairs as a counterclaim is being thrown out?
I don't.
And also, why
let me just deal with the laches and the counterclaims. I see those defenses every day and counterclaims every day, and they're dealt with every day.
Okay.
And I think
Every day, can I just say this? I just had a case today, where the woman came back, and actually the case is, she already moved out. And she got a default judgment on the $6,000, but I saw the stipulation that came from housing court, because now after they're gone, it becomes a civil court case when they ask them for the money. I see in that document that the judge had something about the repair. So when the landlord now wants $6,000, I have to deal with, well, did you do the repairs? So I don't know where you're getting that from, because I just dealt with that today.
Okay, so if there is a situation like that, it needs to go to civil court, you're saying?
No, we deal with it in housing court. Judge Sheares is saying that when the tenant moves out, and sometimes the counterclaims are severed, and then they will sue in civil court to get those counterclaims heard.
Right.
Okay.
And so that's what I said earlier today about the difference between sever and waiver. Were you here with that discussion?
Sever and waiver.
Right. So, okay, so basically, tenants will see that word sever, and they will think that the landlord is waiving the rent. All what sever means is that I'm cutting it from the landlord-tenant case, but I may bring you to civil court.
Right, the
to
small
get that
claims
money.
or whatever.
Right? So basically, that's what happened in this case. That word sever was in there, but nobody explained to the tenant what the difference was. So she thought that she was never going to be sued on the $6,000. So now she's here on the default of the $6,000, right?
I don't
And
think
the
that's
landlord
what-
may or may not be entitled to the $6,000 because in this stipulation, there was some provisions about the repairs. So I have to deal with all of that. But your question was, why is it not there? It's there, and we have to deal with it.
No, I also dealt with latches. Latches that come to court, a case
know
that
what
comes to
latches
court
are.
after 1 year, and it's not being dealt with in housing court. And also, why a supervising agency, an order from the supervising agency
What
becomes...
agency are you referring to now?
Yeah, what is that?
Okay, for instance, an agency like DHCR gives an order that has not been in a building for like 12 years. The rent is $88. They come to court 12 years later or 15 years later, and they said the rent is double. And they give an order,
Who is they?
and the court accepts it.
No, if you produce
an
the order from
agency.
DHCR, the court has to deal with it. But it's upon you to, you can't just say that DHCR did something. You have to go to DHCR and get the order. Because unless the landlord has had the order rescinded, it's still in effect. If it was 25 years ago. And I've had cases where there have been orders from 10, 15 years ago, and they produce the orders, and the landlord can't get any more rent than the order says they can get.
And that's a problem
I don't
in
think-
court.
I don't think
You
you're
have
understanding the question.
You have to bring documentation. If you have an order from agency.
We
that
don't
say-
have an order. The order came from the judge. The judge requested an order from a state agency and accepted it as fact and proof.
Well, it is
Well,
fact
it
and
is.
proof. That's what it is.
I don't understand your point now.
Okay, if it's a regulatory agency that they accepted the order from, then we are bound by that regulatory, for the most part, agency. So if it's DHCR and they said this is what it should be, then we're hard pressed to go against what has been established by that agency. So that becomes a problem. I'm saying you have a right to then try to sue the agency to either get them to rescind, but if they don't, then you're kind of stuck. That's like anything else. If we as judges enter an order, you would have a right to appeal, just like you should have a right to appeal whatever that agency's decision is. And that's what, you need to do, because as judges, we are then going to be bound by that ruling. So you need to try to get that appeal. And I'm saying with latches, certainly latches means that the rent is stale. Not that the landlord can't collect it, but you won't be evicted from your home as a result of those old rental claims. That's the difference. When you sever it, that means that its latches is too old. Why did you wait 2 years? I'm going to sever everything that's over 6 months, let's say. So that it doesn't mean that you don't owe that other rent, that 18 months rent, but you just can't be evicted from your home if it's not paid. But they have a right to take you to civil court to say, listen, they owe me for this rent, I want to be paid, and I get a civil judgment against you. Meaning if you're working, I get to garnish your wages. If you have a bank account, I get to also attach your bank account. That's what that means, the latches. Not that you don't owe it, but you can't lose your apartment as a result of the fact that they waited so long to sue to get that rent from you.
But people have lost their apartments because of it, okay? That's all I'll say.
Okay.
Okay,
But
thank you.
Did you hear the word appeal?
Thank you.
You heard the word appeal. They have a right to appeal a decision before it's too late.
Okay.
And a lot of people wait too
Until it's
long.
due.
That's
Until
why
the
you
marshal's
have
at the
to-
door.
You have to follow the instructions. When we tell you something, we are not telling you that because we don't like you, we don't care about you. We telling you because it's the real deal. Because the marshal will be there.
At the door.
And when you come with the marshal at the door, the marshal's evicting you and you in court. And that's what really happens. Next question.
Thank you.
Good evening.
Good evening.
What are the steps when a minor child is arrested and they are now in the process of getting their record sealed? Is there something that the judge do or an attorney do to get the record sealed? In addition, you had made mention, Judge Walker, about the privilege that you give to some youth offenders in regards to the special.
Youthful offender.
Thank you.
treatment. Correct.
And with that, do they need to put on their record that they have been arrested?
No.
Well, there's a multi-tiered question there. As far as, first of all, with what happens once the youth is arrested, correct? And what Raise the Age did was take the 16 and 17-year-olds out of the equation for being charged as adults. So they get the same benefit as juvenile offenders. What we call a juvenile offender is a 13, 14, 15-year-old. The 16 and 17-year-olds are now called adolescent offenders. Okay, so they're no longer adults. But once they are arrested, the police are required to reach out to a parent or a guardian to let them know that that young person has been arrested and before they're being questioned. Now, there's certain things that they can ask certain questions, but then that gets into legal terminology as far as are their rights. They're being read their Miranda rights, meaning that they understand anything that they say can be held against them. You know, they should have a parent and or a guardian which is available while they're there being questioned. But those rules now are in effect, the same that was always there for juvenile offenders, for 13, 14, 15-year-olds once they're arrested. Now 16 and 17-year-olds also need the parent or the guardian to be notified. All right, now some people would say, well, how long do they have to wait? Because sometimes parents, you know, are working. Or what if the kid doesn't have the phone? You know, one of the things about these phones, which is done to us now, nobody remembers their number anymore, correct? So now, whatever, if the phone was taken or if the phone is lost and you're asking this young person, well, I need to get in contact with your parent or guardian, and they don't know what the number is. And so how long are the police required now to wait to see if somebody shows up for this young person? Okay. I think your next question was about
The sealing of the records?
The sealing of the record. Well, if they get youthful offender treatment, right, then at that point, there is no criminal record. Okay, they are deemed a youthful offender. That's a legal terminology, an adjudication which happens by the court. And so in that sense, there is no criminal record. Now you're saying, can they be asked, have they ever been arrested before? Normally, they can't ask you that anymore. That's not legal for employers to ask, have you ever been arrested? Because people can be arrested and never convicted, right? You could be arrested, I've been arrested, but I've never been convicted. So you see what I'm saying? So to ask somebody, have you ever been arrested before, they're not supposed to, let's put it that way, ask you, have you ever been arrested? Now, if they ask you, have you ever been convicted of a crime, that is different. And employers are, you know, for the most part, allowed to ask that. But if you have that youthful offender adjudication, then no, you can now say, because that is not going to show up in any database. Now, it can still show up on the FBI database, which is very critical if you're going for like a gun license or something of that nature. But that will basically seal the matter at that point, once you get that youthful offender adjudication. The only thing, and as I explained to these young individuals, is that you can only get that one time. Now, sometimes what we try to do is sometimes these young people will have a case in Brooklyn, they'll have a case in Queens, they'll have a case in Manhattan, and they'll have a case in Staten Island. They get around, believe it or not. And it is possible that they can get youthful offender on every single one of their cases as long as it's done in a time, a very short amount of time. So if we feel that this young person has just made some mistakes, but they have now earned youthful offender on all these different cases, with permission from the attorneys, we judges, youth part judges, actually talk to one another. I just had a conversation just yesterday with my counterpart in Queens on a matter where one of the young people has a case in my court and also in her court. And what we're trying to do is get the youthful offender adjudication for this young person on all of his cases. So that way we're able to do that, and that person will not have a criminal record. But that's, as we say, it's that second bite at the apple. And unfortunately, a lot of these young kids, they just don't understand what's going on. I know we talked about jumping the turnstile. I just saw some kids jump the turnstile yesterday. I wanted to snatch them up, because what they don't realize is that that is called theft of services. It's a misdemeanor crime, which you can, if you're found guilty, be put in jail for up to a year for $2.75. Think about that. For $2.75, you can be charged and found guilty of a misdemeanor, theft of services, and be put in jail for up to a year. And what was happening with our 16 and 17-year-olds prior to raise the age is that they were being charged left and right with that happening. They were coming to court, and when they picked up their third or their fourth one, now the attorney was saying, or the DA was saying, you know what, Judge, we can't give a violation anymore. We can't give what was an ACD, an adjournment in contemplation of dismissal. As long as they stayed out of trouble for 6 months or a year, the case would be dismissed. Now we want them to actually plead guilty to that misdemeanor. And this is what's happening, and this is what we talk about with educating the community about what's going on, and how what may seem to be very innocent and fun can turn out so differently. It is very devastating.
Thank you. I appreciate you all.
Thank you for your
My
question.
pleasure.
This is going to be the last question, then we're going to wrap up. Each judge, get ready, because you're going to give like a 1-minute statement, what you wish they got out of this from your court.
Yes, hello. Very informative tonight. I like the thing about the will, because I'm interested in, because somebody left some money for me, and they claim they can't find the will. That's the first thing. And I want to know where I need to go. The second thing is, I was illegally evicted, was never served court papers, and the landlord never notified NYCHA that, so we could, combine the case. So I want to know what is my source, what I need to do, because they took my property, okay, and held it someplace, and when I asked them about it, they say, well, we can't tell you where it's at. It's in another state. So I've been getting to run around. Of course, I have, I'm trying to do everything that I need to do. Of course, I've been injured during the process. I'm trying to take care of everything. But what can I do should I go back to housing court? Because I've been getting to run around and said I was never served. They're saying that I owe money, but they never send me anything. So I don't know how the courts allow this stuff to go, pass through. And this harassment, intimidation, from the landlord. They could have served me. They had my phone number to
Is the landlord NYCHA, or is NYCHA separate in the park?
Separate. They never.
Section 8?
Yeah.
Okay.
And they never notified it, it's just my name on the paper. But meantime, when I went to the office, I asked, well, what happened to my stuff? They said, well, I should have been get the stuff. How are you going to evict somebody and don't serve them and give you the money around and all that kind? I don't understand how the process.
Do you have an index number?
I don't have it on me, but I have it.
Have you done an order to show cause in housing court?
No, I haven't because
That's it. You should do that tomorrow.
Okay.
How long did this happen? How long ago?
I went there right away because I didn't know what to do. About a year, almost a year.
A year?
Why did you wait so long?
Because I was getting the runaround. I went to housing court. They told me that once the landlord gets the marshal, it's done. You know, it's done there.
That's why you should go to an attorney right away, because when you sit on your rights, then you have no, you basically give up those rights.
Where were you told that, ma'am?
It's a 1 year statute of
Where were you
limitations.
told that in the housing court?
Where the borough I used to live in. I don't want to say in front of people, but anyway.
Okay, because that's misinformation. And if
I went there and I said, look, what's going on? This was brought to my attention. They said, go look up your name and stuff on the court file. And I told the landlord, can you give me the paperwork? They said, no, we can't give it.
But the court, the court should be able to, the file should be there and you should be able to see the file.
So
and you should have been able to do in order to show cause to get the case in front of a judge, so you can explain that you were never served and whatever other defense that you didn't have.
So, but I can still do it and see what they say, because they claim that I owe money, but how could I owe money, you know what I'm saying, when I've been paying money to them?
Okay, but that's what you need to do, to get the case before a judge so that you can state, you know, the things that you have stated and then force the landlord to put their proof out.
Yeah.
But it's most helpful to get a lawyer. And you may be able to get a free lawyer if you go into the court and you go to, there's an HRA office in each of the housing courts where you can find out if you qualify and if you are eligible for a free attorney.
Okay.
And in addition to that, there's a help center in each housing court that you can speak to attorneys in order to get information on your case.
On my issue, okay. And one more thing, how do I go about finding about the will that was, does with will, where would I go? Which court would I have to go to get that info?
Sure.
Do you know if there's a will?
Well, I was told by some people in the neighborhood that they left money, the lady left money with me and one of my cousins.
Okay, so you left money, but did anybody ever find the will?
I don't know.
Do you know if the will was filed in the surrogate court?
I don't know.
Come on down. Give us a name.
Right, but if it's not
If it's there, but if it's not filed and you don't have a copy, that becomes a problem. There is a proceeding called a lost will, which is in our miscellaneous department. Remember I said that's the place where everything goes in there, right? All of the miscellaneous type of proceedings that are brought there. But the important thing is that somebody got to have a copy somewhere.
Especially their attorney, if they had an attorney.
Well, if they don't, then that's going to be a real problem. That's like an uphill battle. But come down and see whether or not one is filed. A lot of people don't know that. You can file your will in the surrogate court. You get a receipt, and it just stay there. Now, some people say you shouldn't. That's not true. File it, right? And then you keep a copy.
Because I know that one of the relatives.
Okay, we're not going to take a personal case here tonight. So
Come
we're
down.
gonna
We'll see you
close up.
tomorrow after you go to the attorney for the wrongful eviction.
Okay, thank you.
So now we're going to close up with a special part. Every judge will start. You have something you want to say?
Go ahead, you go first, you believe.
Okay, we want to start. You're going to be last. I'm going to be last. Let him go first? Okay, we're going to be generous to our brother and let him be first because his birthday was Monday. That's our birthday present to you. And we just want you to, close out with what would you like them to have received from you regarding your court? Like one of the best things that they need to know.
best thing that they need to know. Okay. Parents, grandparents, uncles, aunts, brothers, sisters, go into your kids' rooms and toss those rooms, okay? Let me tell you, I remember my father took my door off the hinges because I thought yes, he did. He took the door off the hinges because I thought I had privacy. I can't tell you how many search warrants that I sign based upon information that's given to the court by friends and family members who will let the court know that there's a gun or there are drugs or there's some other illegal activity happening inside the apartment. Why? Because so-and-so pulled it out from underneath the bed or out of the closet and showed me. And so I signed that search warrant based upon that information. The police go, they issue that search warrant, they go into your home, and if you're in public housing, problem. You may not, exactly. So all I say is you may think that your kid is the best kid in the world, maybe the A student, the one that never gets into any trouble, but maybe holding something for a friend. And you're the one that now is out. You're the one that's now coming with that kid down to the precinct. You're the one who's now coming to sit there in the court while I'm there wondering what's going to happen, which all of it could have been preventable. So if you don't take anything else away, please take that.
Everybody should have gotten one of these. And so that was Judge Craig Walker. Put on your paper, how you want to identify it. The only male, the good-looking one, whatever. That was Judge Craig Walker. Now, next will be Honorable Carolyn Wade. Right how you want to describe her on your paper.
Okay, so initially I told you that I do a lot of medical malpractice cases, slip and fall cases, elevator accidents, car accidents, but my biggie is the mental health cases. And, you know, like someone said, if you see something, say something. You know, sometimes you live with people or you have relatives or friends and they start acting different or they start not communicating, or they don't go to work, or they don't go to school. Something's just not right, and you can tell. But I'm gonna tell you that there's something known as the mobile crisis unit. Like when you have a friend, or even your husband or your wife, you have an option. You could call 311, you could call 911 if it's really serious, if you think the person is a danger to themselves or others, or you could call LifeNet. Now I'm gonna give you this number. It's called LifeNet, and it consists of various mobile crisis units, like a truck that has a social worker, a physician assistant, and a nurse. And they go around the city based on referrals made by certain agencies. And so if you have any family members that are not acting right, or you see somebody that's not acting right, like I said, call 311 or 911, and I'm gonna give you the number for LifeNet. Some people ask me this all the time. People even call me at 3 o'clock in the morning and ask me, you gave me the number, but I can't remember. So I'm going to give it to you because you never know. And it's 1-800-LifeNet or 1-800-543-3638. And in the past few weeks, we've had a lot of things on TV. We've seen a lot of things on TV where some mentally ill individuals assaulted other people. So you just never know, but keep this number in a safe place. All right, I hope that you got a lot out of this. 1-800-543-3638. So it's 1-800-LifeNet, but the LifeNet is 543-3638.
Judge Ottley.
Okay.
The one thing that I'd like for all of you to do is to go home and get your affairs in order. If you do not have a health care proxy, if you do not have a power of attorney, if you do not have a living will, if you do not have a last will and testament, for those of us who believe you don't have anything to give away, yes, you do. Yes. Because some of your family members may want that leather jacket, right? And I'm telling you this because you may think that it's nothing, but somebody sees it as something that's sentimental to them. They want it, and they come to court to fight about it. Okay? And I won't even begin to speak about the money. If you have anything in your account, I don't care if it's $10, somebody wants it. The other part, parents, those of you who are caregivers to your parents, if they have the capacity and they're talking to you every day, now is the time to have these serious discussions with them. And a lot of our parents don't want to tell us their information, right? And I was the guardian over my dad, and I will say it again, my guardianship court, it should be the last resort. The fact that I had to go there and become the guardian over my father was very disheartening for me. It is overwhelming, and even someone who, as an attorney, knowing what needs to be done, I didn't want to go there. And I had the court, to know that the court was now going to make decisions, and I wasn't guaranteed that I would be the guardian and have someone come out and speak to the community about how I interact with my dad. And I come from a family of 8, but everyone in the family said, no, you do it because you're the attorney. I'm saying to you, get it in order now. So I don't want you to come and blame the court, because sometimes the court can't appoint you as the guardian. But if you have it in place already, it's something we have to look at. Some of these Medicaid planning issues, they're so intricate that you don't know how to deal with it. So you may need a geriatric care manager to do this stuff. Get it in order now. Start your estate planning now. That's what I say, so you don't have to come to court.
Judge Theresa Ciccotto, sorry.
If you're contemplating a divorce, when we get married, it's usually for better, for worse. Unfortunately, the younger folks don't necessarily have the patience to stick it out like older folks do. But if you're contemplating a divorce, what I urge you to do is consider everything. You're looking at an extraordinarily expensive, a very, very involved proceeding. If you can seek out some help, therapy, couples therapy, to help you, it's the way to go. Folks, anything that's acquired during the marriage is considered marital property. If you have property that you had before you got married, you're not necessarily safe. Like I said before, if you commingle funds in a joint account, even though the funds were left for you, that now becomes both of yours. If you have a house that's yours, but your partner has made some major contributions, like helped you pay the mortgage, did a lot of repair work, that person's got the right to challenge the ownership of that home and could get a portion of that. Lastly, I want to tell you the most important thing is the law mandates that when there's any issue regarding children, particularly in custody and visitation cases, the law mandates that we put the best interests of the child first. And not only that, if you're sitting in matrimonial, you also have a moral compass that dictates. And what does that mean? Essentially that a child needs to be safe and well cared for. And you have to consider that your children did not ask to be born. They did not ask to be part of this controversy. And you have to make every type of effort to try to protect them from your arguing, from any disparaging comments you make, because they remember this. They internalize it, they blame themselves. And the bottom line is, too, as parents, you have a duty to protect your children at all times. I suggest that when you're contemplating a divorce, there is so many things online that you should look at. Like in New York, we have equitable distribution. Equitable does not mean equal. This is a process that has so many turns and ins and outs. So before you're contemplating it, know your rights. There are so many things online. There are uncontested documentation if you don't want to have to go to court that you could download. And believe me, that will help you make a decision, because sometimes there's a saying, it's cheaper to keep her, you know? And I used to laugh when I heard it.
On that note, Judge Lorna McAllister. You get ready to start us off. Judge,
you make efforts.
That's
to try
Judge
to
Theresa Ciccotto. We moving on to Judge Lorna McAllister.
So, what I want to leave you with is, don't be afraid of the court. As Judge Sheares said, if you get something in the mail that if you don't understand it, or if you do understand it, and you know that you're being sued, don't be afraid. Come to the court. There's always people there who can help you. We're not there to hurt you, we're there to help you. And 9 times out of 10, things can be worked out. There's always a way to try and work something out. So don't ignore it, because it's only going to get worse for you if you do. So we're there to help, even if it's a language problem. If you're afraid to come because you think you don't understand, we have interpreters. It can be worked out. So never be afraid to come to court.
Judge Deborah Dowling.
Well, the one thing I want you to take away is being in Supreme Court on the criminal side is serious business. You're being accused of a felony. It is your case. You have a right to ask questions of your attorney. You have a right to understand everything that is going on with your case. If your attorney is not answering your questions in the way that you feel that he should or she should, you always have a right to inquire of the court. Because the bottom line is, it is your case, and you have to make sure that it's resolved in a fashion that you would like it to be. Because again, the only 2 options are, you're either gonna enter a plea or you're gonna go to trial. And I tell every defendant who comes before me, the best that can happen is after a trial by a jury is not convinced by the people's evidence beyond a reasonable doubt. So you are acquitted of all counts in the indictment. The worst that can happen as far as you're concerned is after a trial by a jury believes the people's evidence beyond a reasonable doubt, and you're convicted of that count. Because certainly you may face significant time in jail. So you have to weigh the options that you have, and you have to make the best decision for yourself. Yes, listen to your lawyer, and sometimes I think people have a skewed idea of what they think the lawyers can do for them, but certainly they can't make the people give you any particular deal. They can ask for it. You may not be entitled to receive it. If you don't, you still have to assess and weigh those options and make the best decision for yourself. Because the bottom line is, you have to live with it one way or the other.
Judge Harriet Thompson, our surrogate.
I just want you to know that you're welcome in the Surrogate Court. It's a good court to come into. My calendar is tomorrow. That's why I'm half sleepy now. But I want to just reiterate what Judge Ottley said. I see younger people dying younger and younger every day. It is important when you're in your 20s and your 30s to start thinking about death. And it sounds like a morbid subject, but it's just preparation. And remember, you can always change a will if you want to. You can add to it. You can do a lot of things to it. But understand that you're not going to be here forever. Make your requests known and let the people know where your documents are. They don't want to be digging through the house. Don't leave cash in your home. I know a lot of old Southerners and a lot of people from the Caribbean do that. Not a good idea. And I would just say, lastly, for those that are husband and wife, understand you cannot disinherit your spouse. Just understand that. They're getting some money.
Legally married, y'all.
Period. Legally married. Thank you. And understand that one of the biggest fights is between half-bloods. They fight to the bitter end. And have that old Bible that your family tree is in, so if people don't know the history, they can at least be able to get at least a line of heirship. So those are some of the really important things that I see in the surrogate. But please, come down. Great staff, as I told you, my court attorney referee Meredith Jones is there, as well as Mr. Pastil. It's a great group, and there's a great help center there. Come down and see us. And thank you for your time tonight. You guys have been a great audience.
Judge Gonzales.
I want to echo a lot of things that have been said. First thing is that don't ignore any papers that you receive, and I think Judge Sheares started with that. Secondly, I think you need to educate yourself. There are help centers. Look, some courts have websites, and it pays to get the information before you come into court. And when you do come into court, be prepared. Bring your documents. It's very important that you have proof of whatever your claims are. It's one thing to say it, but it's another thing to show. Bring your receipts. Bring whatever you have to prove your claim.
Don't bring the roaches.
Some people do bring the insects, but yeah. And it in a jar, it's proof, but pictures will work also. And as Judge Dowling said, with any court case, there are two avenues that you can go to. You can either try to settle the case or go to trial, but you must understand what the consequences are after trial. And if you educate yourself sufficiently, you should be able to make an informed decision as to how you wanted to proceed with your case.
Amen.
And yours truly, Judge Robin K. Sheares. I just want to say thank you to all of the panelists. They said everything I want to say except for one thing. You all have to serve on jury duty. Because I'm going to give you a little scenario. Family friend sat on a jury, 17-year-old boy. They had him for robbery. And the only way that that boy got off is because that one black woman was there, because the thing he had for dinner was fried chicken and rice from the Chinese restaurant. They believe everything he said, except for nobody goes to the Chinese restaurant for fried rice and chicken. That woman had to tell them, I have a 17-year-old boy at home, and you know what he had for dinner last night? Fried rice and chicken. So you gotta be on jury duty, and you gotta be vocal. That's why sometimes our people go to jail and they are innocent, because we don't sit on jury duty to give our perspective. To God be the glory. Now you think these judges did something? This young lady right here, Miss Brianna Suggs. Always get it wrong. Father was here too, because he supports her. She made this happen. Miss Suggs made this happen. So our judges, we love them, but if it wasn't for this young lady, it could not have been done. And last but not least, our president of Church Women United, we thank you for co-hosting this. We thank you for co-hosting this. To God be the glory. Everyone get home safely.